All right, I'm ready to go. Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission meeting. Thank you for joining us. We are using Zoom with a goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raise hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder that this is a video conference and to please be aware of your surroundings behind you. All LSTFC and committee meetings will be recorded and posted to the State Bar's website. Zoom captioning is available. To enable, select live transcript at the bottom of your Zoom screen, then select enable auto transcript. Thank you.
Thank you, Kim. So welcome everyone. We've got a full agenda today, several new members to welcome. Before we get started, should we do roll call?
Yes, I'll go ahead and do roll call vote. Alsaraf?
Here.
Connolly? Escobedo?
Here.
Melrod? Patients, you're muted. I believe you're here. I just wanted to confirm. We're doing attendance, so I said Melrod. Nice. Patients, can you hear us?
No, I didn't hear you. I'm here.
Okay. Sure. Thank you. Alikani? Babcock? Blakemore?
Here.
Campbell? Galkin? Gonzalez? Huang? She's here. Just promoted her. Okay. I believe Tony, you just joined, so if we can confirm. Tony Huang, sorry. I believe you're here. I just wanted to. Okay, thank you. King?
Here.
Klein?
Here.
Mahoney?
Here.
Morales?
Here.
Pryor?
Here.
Judge Rosie?
Here.
Handel?
Here.
Smith? Here. Stalker?
Here.
Vargas?
Here.
Wonderful. So that's 15 members. I'll go ahead and do roll call for our advisors. Justice Rodriguez.
Here.
Right. Sorry, Judge Wayne Gutierrez. Okay. And then Judge Yang. Okay, and then our liaisons, I see Selena's here from LAC.
That's it.
Wonderful. Melanie Snyder. Okay, and then I'll just note State Bar staff. Thank you. We have 15 members and quorum as well.
Great, thank you, Crystal. So the next thing we're going to get to is public comment. If there are folks who have public comments, please raise your hand. Before we begin public comment, though, I would like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or related to matters that are within the jurisdiction of our agency. And specifically, the Legal Services Trust Fund Commission exercises oversight on the administration of grant programs that fund local and statewide civil legal aid organizations to advance its mission. This commission does not have authority over attorney discipline, and there are no attorney discipline matters on the agenda for today's meeting. So with that in mind, I will open it up for if there are public comments, general public comments. It looks like we've got one hand raised in the attendee pool. Ariel Brown.
Hi everyone. So my comment has to do with the grantee reporting proposals. I don't know if you all would prefer to wait until that agenda item.
I think, why don't you go ahead and share your public comment now?
Okay, Thank you. So my name is Ariel Brown, and I'm providing comment on behalf of the Immigrant Legal Resource Center, or ILRC. So the ILRC greatly appreciates the increase of IOLTA funds in recent years, including the historic amount for 2025. This increase has allowed us to expand the work we do, but as our grant amount has increased, so has our reporting. For example, the Smart Simple platform was a big step up in terms of reporting, and what is required for advocacy reports is significantly more than what it used to be. And so we thought it might be helpful to describe what this reporting looks like for us currently, and then what some of the proposed changes would entail for us. So last year, we provided information to the State Bar on over 75 different trainings that we offered to QLSPs. And for each of the 75 trainings, we had to provide our role, the subject, date, location, number of total attendees, number of QLSP attendees, and number of different QLSPs served. We also provided information on 24 different task forces, where we had to list the name of the task force, number of meetings, number of participants, number of different QLSPs participating, and the applicant's role for each task force. We also listed out more than 30 different written resources that we provided to QLSPs, providing title, distribution method, and number of copies distributed for each one. And then for our advocacy efforts in impact litigation, we have to provide extensive narrative reports for up to 20 separate advocacy efforts. And then in a chart at the end of the annual assistance summary in the IOLTA EIF annual application, we must detail how many instances of training services, technical assistance services, and advocacy support services that we provided to each individual QLSP. So this reporting is currently pretty arduous, time-consuming, and we have built entire data tracking systems around the State Bar's reporting requirements. So if we need to provide different types of information, we will need to modify these systems, which will take time, resources, and staff training. So for example, if we have to provide more information on our individual technical assistance and consultation services, as is proposed, we're looking at modifying our internal data tracking for over 1,800 different instances annually. And so if the commission is looking for more information on technical assistance services we provide, we propose requesting a few paragraphs on the qualitative nature, where we can describe the types of questions that we receive, but to collect aggregate data for a grant period that starts in a little over a month. Am I able to keep going? I see I'm at time.
You are at time, and I should have mentioned at the beginning that we give 3 minutes for public comment.
Okay.
But I'll let you finish your sentence. I think you're in the middle of a sentence.
Okay.
but,
Well, I was
yeah.
just, our suggestion was sort of to provide more narrative information instead, because, you know, for the bigger support centers, this is just going to be more burdensome for the ones where you should probably be the least worried about how we're spending the funds, because we're already doing a lot. So that was sort of the gist of our comment. Thank you.
Thank you very much. And do we have one more? Is it Lee Farron?
Hello, good afternoon. Thank you. My name is Lee Farron. I'm an attorney at One Justice, and I'm also commenting on item 7.3, the reporting requirements. And I just wanted to say briefly, we do recognize that, you know, reporting changes likely do need to happen, and that they will be helpful to the commission and the bar to better understand the work that we're doing. We have two kind of main concerns. We're a little bit worried about providing a broader level of detail for the technical assistance that's provided to QLSPs. It makes sense that the bar would want a better understanding of the type of assistance being provided, but we're worried about that the level of detail that's suggested in the memo could have a chilling effect on some QLSPs. For instance, particularly at One Justice, where QLSPs are often asking for assistance with sensitive organizational management topics that they may not want disclosed. So we would just propose that for the description, that the bar would allow for some broader categories of substantive work and maybe a slightly more generic description of the services, so that the QLSPs can be reassured that they have some amount of confidentiality when they're receiving support from an organization like ours. And then the second is the requirement to partner with the QLSPs on the design, delivery, and evaluation of services. Makes sense. We're trying, I think what would be helpful is to have some clarification maybe, or understanding of what level of QLSP involvement is needed. We don't want to be constantly surveying people like all year long, overburdening them with requests for information and guidance. And we're also a little worried, just, I mean, for those of you that run MCLE programs, you know, like the return rate for evaluations is very low. And so we're a little bit worried about, you know, what will be expected from support centers if we don't get responses to our requests for input and guidance and evaluation. But hopefully, I think along the lines of what the prior commenter said, maybe we can show other ways in which we partnered with folks to ensure, you know, whether it's through narrative responses or something else. It just feels like it would be a lot for each QLSP to have to respond to surveys or other information from each support center, or even some subsection of support centers once or more per year. And then I think just that conversation about how that interacts with deeming, it's not something that One Justice has to worry about, but I think for other support centers, they're already being asked to articulate sort of the need. And so figuring out what their involvement in the evaluation of services, as well as their involvement in the deeming process, how that would work for the QLSPs and the burden on them. And that's all. Thank you so much.
Thank you, Lee. Looks like we don't have any further public comments. So, and I think for those who are new to the commission and new to some of these issues, this will come into finer focus when we get into the discussion a little further down in the agenda. So I do want to start by saying welcome to everyone to the first meeting of our new term, and I want to welcome. We've got a new set of. We've got a new executive committee. We've got a couple of folks who've been reappointed to the commission, and we've got several new commissioners. So I want to say welcome to everybody. Our new executive committee. I'm now joining Erica as co-chair of the commission. And we're joined by Patience Milrod and Efrain Escobedo as the code vice chairs. So we are also welcoming back as reappointees Jason Galkin. Is Jason here? Jason Galkin and Tammy Mahoney as well. And we have, let's see, 5 new members who I'd like for the new members to not just raise their hand, but also maybe to introduce yourselves to the group. We're going to have an in-person meeting where we'll get to know each other better, but I'd love to sort of put each of you on the spot for a minute just to introduce yourselves to the group. And I'll name the folks who are joining us. It's Kenneth Babcock, excuse me, is a new member. Judge Kristen Rossi is a new member. Aaron Smith, Robert Stocker, and Judge Julie Wen Gutierrez is an advisor to the commission. So let's start with Kenneth Babcock.
And I mean, Ken could not join us today, but he will
Okay.
be.
I see that. How about, all right, Judge Rossi.
Hi, everyone. Good afternoon. I'm Judge Kristen Rossi. I am the Chief Judge here at the California Department of Insurance. Very popular state agency right now. And I just finished a 5-year term on COAF, Council on Access and Fairness, where I was chair for the last 2 years. And I am thrilled to be here with all of you and to play catch up a little bit on all these issues.
Perfect. Thank you, Judge Rossi. Welcome. How about Aaron Smith? Is Aaron Smith with us?
Yes, I'm here. I'm both
All
in
right.
the room and here, so you can see me a little
Okay,
bit.
perfect.
I am just one person. Really nice to be here with all of you. I'm very excited to be joining the commission. I'm the co-founder and past executive director of Family Violence Appellate Project, which is a support center. Very familiar with all the reporting requirements that were just discussed in the public comment, and very happy to be joining the legal aid community from this new vantage point. I left Family Violence Appellate Project about 1.5 years ago, and now I am the author of the California Judges Bench Book on Civil Proceedings. Thanks for having me.
Awesome. Welcome. Thank you. Thank you, Aaron. Is Bob Stocker?
Yeah, thank you. I'm Bob Stalker. I started in legal services. Angie King and I were VISTA volunteers in Oregon quite a few years ago. And after that, I practiced in Seattle.
I recognized you.
We last saw each other at a Bob Dylan concert, I think.
We won't go there.
Okay. I practiced in Seattle with legal services for about 20 years and came to California a little over 20 years ago and worked for legal services in Northern California. I was in the Vallejo office, retired 8 years ago, and now I'm currently serving on the board of LSNC.
Terrific. Awesome. Welcome. And Judge Wayne Gutierrez.
Oh,
We're having some trouble hearing you. I don't know if it looks like you're off of mute, but we're having some trouble hearing. No. It seems like there might be an issue with your microphone, maybe. Can you hear us? Okay. Yeah, unfortunately. Oh, there we go.
I think yeah.
There we go.
I had to switch my microphone. Sorry about that. Hi, Julie Wayne Gutierrez. I am currently a Superior Court judge sitting in Sacramento Superior Court. I have a family law assignment right now, so I have a lot of self-represented litigants appearing before me, some of whom use legal aid assistance. And prior to that, I was with the Attorney General's office. I worked in the health, education, and welfare section. So many of the recipients of services were recipients also of state benefits. So I'm familiar with the system, but I think most relevant is I used to be an attorney member of the Legal Services Trust Fund Commission and formerly served my 3-year term and then served another term as co-vice chair. So I'm so happy to be back. Such important work that this commission does. So thank you for having me.
Awesome. Welcome back. That's great. And it's wonderful to see, you know, the level of experience, background, folks who've been on the commission, you know, in the field out there that bring, you know, a lot to the commission. You're joining or rejoining a really distinguished group altogether, myself excluded from that. But there's a lot of folks here who bring a lot to the table, and I'm excited about this year. I think we've got a really good group altogether this year. So we have a lot planned. There's a lot of changes happening to the commission, all for the better and all for the good. And so we'll get into some of that. So I'm gonna turn it now over to Dwan to do a director's report.
Thank you. I mean, congratulations on your appointment to chair. And I know Erica will be joining us shortly. So I just want to welcome everyone to the new term and welcome our new commissioners. We really look forward to learning from you and your expertise. So I'm going to do a couple quick updates. One is on IOLTA revenue. I'm also going to provide an update on some of our legislative advocacy. And then I'll turn it over to Crystal to do an operations report. So the first is the IOLTA revenue. We have a couple slides prepared that Crystal's going to pull up, but let me just give a little bit of background before we get into the slides. IOLTA, for our new commissioners, and I think actually everybody's familiar with this terminology, stands for Interest on Lawyer Trust Accounts, and it's really like the foundational grant for our program. It's the grant that started the Legal Services Trust Fund program, the grant that started the Legal Services Trust Fund Commission. So at every kind of commission meeting, I provide a revenue update just so that we can track how, in comparison to our projections, how we're doing. And so you all kind of get a sense of what's going on, because that's such a foundational grant for our program. It's been they've been very large distributions the last few years. We're going into a distribution for next year that was approved earlier this year of $252 million. So a big amount that's being distributed to the grantees, but we all know that because it tracks, the revenue comes from interest rates. So attorneys are required by statute to put into interest-bearing accounts where they're holding into client trusts revenue that's nominal and short term, and then it gives us the legislation that allows the state bar to remit those the interest, and then we distribute them as legal aid grants. So it tracks interest rates. So interest rates, if you all have been following in the news, have been now starting to go down. So this has been kind of interest to our programs, and we pulled these numbers really recently. We had a couple weeks ago a Pathways to Justice conference where there was a pre-conference meeting where we shared kind of some of this revenue. So, okay, maybe go to the next slide, Crystal. Okay. Okay, so just really quickly, so revenue had been flat for about about 5.5%, but we had anticipated earlier this year when we went to do projections for the remainder of this year and next year that they're going to start to drop, and in fact they have started to drop. So a couple months ago they went down 0.5%, which was a little bit more than what we had originally projected. We were projecting 0.25% of a drop, and we went 0.5%. However, our revenue is still fairly strong because we also projected that the net assets, so the amount of money that's total in the kind of IOLTA, all the IOLTA accounts, would drop a little bit too, but that didn't happen. And so because that's remained strong, even though IOLTA, the rate has dropped a little bit more, our revenue stream is still fairly strong. If you've been following the news, just literally yesterday, there was another 0.25% drop, which we actually built into our projection. We created these slides a few weeks ago. We had already built that into our projection. So we're at 4 3/4 there, and then we anticipate one more drop for this year because there's one more Federal Reserve meeting. And the Federal Reserve has already indicated, they've issued statements saying that they plan to drop another percentage point in 2025. But there is obviously a big however, because there's a change of administration now at the federal level. And so we do not know how that's going to impact interest rates. If you follow the news and you pull up the news articles, there is a sense that with the new administration, the rate drop will either be flat, or there are also articles saying that they might go up. So we didn't build in any of that. We didn't modify our projections based on the latest elections. We have kept them based on, all the other research that we've done in the past. But we say that to say that we are tracking these trends really closely. And if there are movements any which way we work with national consultants, and we are in close contact with IOLTA programs across other states. And if there's a sense that it will move differently, then obviously we will build that into our projections the next time we kind of come together. Okay, next slide. Okay, so here's kind of figures for you to wrap your heads around. So earlier this year, when you went to approve the distribution for 2025, we projected that we would close this year, 2024, with about 187 million. So we did have that rate drop, but our revenue is still fairly strong. So now we have revised that to 206. So we're going to be netting about $18 million more than what we had originally projected, which usually if we over project, then that just goes into reserve. And these figures are separate from a $25 million reserve that you have fully funded. So let me just pause there to see if there are kind of any questions. But that's the big programs had been calling and were a little bit concerned. There's rates. Is it going to impact our distribution for next year? And the answer is for next year we are very good in terms of maintaining that $252 million distribution. Okay, next slide. Okay, and this is just a slide on our investment income. This is where we have put our money, and you'll see we're going to be netting about $7 million of investment income for this year. And a lot of that is because the IOLTA revenue has been so strong. We put it in really safe government bonds, and even then we're getting a very good rate of return for it. Okay, next slide. Okay, so here's what we built in because programs have asked us, for their budgeting purposes, for us to kind of project in 2025 and 2026. We always give the big caveat, it's so difficult to project out even 2 quarters, much less 2 years, but we do it. We do it just so there's like some starting point for programs to like budget and hire and so forth. But honestly, given the environment, given everything that's going on, this is becoming really, it's very tenuous. So again, 2025, we're projecting a 1% decrease from this year, and then another 0.5% in 2026. So this is what the numbers would play like in the next slide of what our revenue would look like. Okay. So the first box there, that's the 187 number that you all had projected, which we now know we're going to be over 200 million. Then for 2025, this is where the dip is going to happen. And we've been messaging with programs that the distribution next year is really like a once in a lifetime distribution. This is where, and you know, 122 is what we're projecting for 2025, and then 2026, about 105 there, 105. Okay, so those are all of our slides, but let me, I'll just throw it out there. If there are questions or comments on revenue. These are still very large.
Looks like we've got, sorry, Duan.
Oh, I was just saying. I was just saying, these are still very large distribution. Just to remind the commissioners, right before the pandemic happened, we were at a record-breaking distribution that year of $55 million. And so it's just the numbers of the last few years are just so astronomical that I think sometimes it's easy to forget that 55 million was a benchmark just a few years ago before the pandemic. So you want to share?
It's incredible. It looks like we've got a couple of folks who want to make comments.
Unshare? Yeah. Sorry, we'll unshare the screen so that we can all see each other again.
Okay. Selena?
Mine was just a clarifying question on that slide. So in the middle of that slide, you just stopped sharing. It says 122 million, I think. Does that assume the carryover of the additional 18 million from 2024, or are you just looking at 2025 projected revenue?
Oh, you know, that's a good question. Heidi or Micah, are either of you on that can answer that really quickly? If not, then we'll ping them and get you that. My gut is yes, but they're the ones that pulled the slide. Are they on, Crystal? Sorry,
Heidi is on.
Heidi's on. Okay, could you promote Heidi?
Yes.
And maybe you could show the slide just so Heidi could answer with the number.
The last slide. Heidi, did you catch that last question?
Yes, I did. And so I think my understanding is that it's based on the way we do the projection, and Michael did it and I didn't do it, so I haven't been in the weeds with it, but we do roll forward any sort of net fund balance at the end of the year. So that would be rolled into the 2026 period, because that's where it would roll to. That makes sense.
That's what I would have thought too that he would have done, is rolled it in, and then the 25 is just the 25 million reserve is just separate. But if that is wrong, we'll send out an email to the commission after we check with Michael.
Yeah, and just to restate my question, so it could be answered later by email. 2024 on this chart shows your original projection of 187 million. 2025 shows 122, and then 2026 shows 104. And based on your assumptions of a decrease in interest rates, that makes sense. But I'm just curious where that additional, 18 million goes.
Okay.
So it is part of the equation that we do each year to come up with the allocation. So we add in all the revenue, we subtract administrative fees, and then the other sources that also fund IOLTA, the Justice Gap and things like that. And then at the bottom, then we have the net balance from the prior year, and so all of that gets added and subtracted together to the bottom with the net fund balance available for distribution, and so that's where we select the number from. So it does get rolled forward.
So, Selena, are you asking if that 18 is being factored into the projections for the next years? Is that also?
Yeah, and just a timing of when this slide was created, because this slide shows what the staff's projected in the past, which is 187 million. We now know that was cautious. And so it's, when the slide was created, was that 18 million additional revenue captured?
We think yes. Selena,
no, not in the 187. So
Okay.
on here, this is only the anticipated revenue. So this does not include any fund balance that remains. So any fund balance that remains will go out in the 26th year.
Okay.
Oh, and actually for the new commissioners also, that what's a little bit confusing, our revenue for this year is what determines next year. So the revenue for 2025 is what will determine the distribution for 2026, if that makes sense.
Okay, terrific. Thank you guys. Ephraim?
Do you want to share?
Yeah, thanks. I mean, John, thanks for the presentation, and it's great to see kind of that despite kind of market fluctuations, there's still solid revenue. We still continue to be able to advance the mission. I wonder though, and you mentioned a little bit environment and kind of the environment we're in, and we've had this conversation before, but in looking at our financial position as a fund and thinking about our mission, I can't help but think about our current situation with regard to what we might be seeing as far as policy and enforcement shifts nationally. And I'm just thinking about what we lived through in 2026 and 2020 in terms of the way that the legal aid safety net was strained, particularly providers doing work in the areas like removal defense, worksite raids. I know communities, particularly like LA County, San Diego County, Southern California counties are readying, and there's a lot of concern about the state of the nonprofit legal service providers' ability of what they'll be called on to do. And when you mentioned environment, I also know that at a statewide level across other agencies, they're actually not in the same positions. And there's a lot of talks about how there will actually be less funding to support programs that are going to be strengthening those safety nets. So I just wonder, looking at our financial positions, are there any considerations we could give to how we look at our position relative to what the needs are going to be in the next few years, and what opportunities staff might be thinking about how we're responsive to the way that impacts are going to roll out on how communities are going to be impacted here. So I'm just curious, looking at these assets, like what's the ability for them to be responsive and to target and be ready to play the bigger role with other agencies in the state that are going to look to make sure our protections and ability to protect communities are there.
That's a really great comment and question, Ephraim. And I think like with the commission passing the new strategic plan, I think we are moving into that space where the commission is kind of thinking about those kind of policy considerations and thinking about where gaps in legal services that we could plug in the state. For IOLTA, though, in particular, there's not a ton of flexibility in terms of how the money gets out because it's a statutory formula that's distributed. However, I'll say, and this goes to my next update that I'll share now. Earlier this year, we did work with the Legal Aid Association of California to try to change AB 6033. So this was legislation that's in the state bar fee bill, but had for a number of years directed the Justice Gap Fund. That's the money that we collect. So that's like attorney donation that goes into what's called a Justice Gap Fund. That then, what the statute is now, that gets rolled into our IOLTA distribution. So we had been talking for a few years of whether, because IOLTA revenue has been so strong, and that pot of money there wasn't that large. It was anywhere between $6 and $8 million a year. That whether we could open it up so the commission could have more discretion. And the language of the statute was to address urgent and emerging issues. So at the time when this was drafted earlier this year, what we had at the forefront is disaster relief, because there is no money that's dedicated to disaster preparedness in California. But that was just one example. It would give the commission more flexibility to work really in concert with LAC and the Legal Aid Association to identify areas that we could kind of invest in, that we could be responsive really quickly. The update for you all is we did get consensus support. We worked closely with Selena with the community to kind of address concerns. And we did approach the legislature, and there was a technical, I don't know even know how to phrase it, a technical, I guess, mix up where it wasn't passed this year, but not because I don't think there was support for it. So we are very confident that it will be passed next year. So if it does go the way that we think it will go, then that will open up more discretionary funding for the commission to be responsive to the community. And I think this money, I really had wished that it was passed now, because this would have been the really perfect opportunity for us to be responsive, given everything that's happening in the environment. We can't do it this year, but I think this does give us a really good opportunity to interface with the legislature and the governor's office to say, look, you know, and we've already seen, like, if you open up SF Gate right now, the governor's already kind of mobilizing and talking. And I think we should be at that conversation in concert and in coordination with LAC to say, this is what legal services can do, what are the needs. But I think this is what you say, Efrain, is what I think a lot of us are imagining as the commission's role. So
but I have a question, not necessarily dissent, but well, people can interpret it how they want. If we anticipate the volume of potential litigation because of you know, strong enforcement of immigration laws as the Trump administration sees it, are we going to prioritize? And I don't mean to say anything negative about any of these issues, because importance differs, but of course, Trump ran significantly strong when we talked about the community in the Latino community, which indicates it's not, there's no one unified voice. But let's take two obvious issues that come out. There's the idea that, are we going to see again family separation and have to make decisions on that versus, and I don't mean to offend anyone, but it's clearly it's a much smaller issue. You know, the whole thing about surgery for trans who are not properly documented. Are we going to be called on to make decisions with the amount of funds that might be necessary? I mean, I think that's something we have to think about if there's this full frontal assault on every aspect of immigration. I read the speaker's comments, Speaker Rebus, that basically is, you know, we're going to go everywhere. Wherever it is, we're going to fight. And and not that anyone cares, you know, but I didn't think that was a good strategy politically or legally. But we should focus on what we see are the critical issues. And we all remember the family separations scenes. Anyone have any thoughts on Ephraim's, I think, excellent question? I don't think it's such a simple an answer.
Selena, you want to go ahead?
This isn't direct response. I think the great news is that we have, y'all have 115 grantees throughout the state who focus on, deeply focus on issues, and they have been scenario planning for months about the impact to their client communities. And a couple of things that have changed in the last several years is that you now fund a large number of large immigration providers, which wasn't true 8 years ago. Just in the past couple of years, larger immigration providers have joined the IOLTA community. They are very well networked in with everyone else. We are doing a great job cross-referring to each other and collaborating with each other. And so we all know that if there are federal changes that impact Californians' rights, organizations are working together, and it's not expected that every organization is an expert on every issue, and y'all don't need to be experts on every issue. You just have to understand that your grantees, either those have deep substantive knowledges in one issue or a couple of issues, or they have deep connections to the local community, and they're shifting a lot to meet community needs. And I think the best thing y'all have done in the past 2 years is allow your IOLTA grants to be multi-year grants, because that allows these organizations to really shift and perhaps hire staff that they did not think they had to have a year ago. And so you have offered a lot of flexibility to your grantees to respond to whatever their communities need. So I know there's a lot of fear in our communities that we serve, but we now have 115 grantees who are really doing excellent work.
I found it interesting you used the word if. That's a rather optimistic word.
Yeah, I mean, I think that's a great point, Selena, and Judge Klein. I think what I would say is, because of that complexity, I think one, more so than responding, it's like, as a commission, making sure, are we inviting information so we could see what's actually playing out, right? There were a lot of let's focus here, and then realized that we needed resources over there. So I think the staying informed, maybe not reacting to every little thing, but staying informed. I think to Selena's point, I think that's why I had raised it. And I've been encouraged and excited to see the growth in that segment of the legal service providers in terms of grantees. I think my thing is thinking about, we know that there will be added pressures. We know that there will be added demands, particularly in that segment of our grantees. And so being in tune, connected, and thinking about what are additional resources that could be deployed to meet those demands, to cover that. I remember back then when, I was in philanthropy, and the biggest thing became, providing resources to legal service providers so that they could grab offices out at the Adelanto detention centers, because they needed to be out there. They couldn't just be driving every day. So I think it's thinking about adaptable strategies like that, and knowing that our IOLTA funds are good, but maybe for a segment, just like we've created other special grant programs, we could maybe be responsive that way. But I agree and think it's important, Judge Klein, to your point, it's like, don't get too ahead of it and look at everything. Let's be strategic, work through our grantees and see where those resources. But my point here was just, is it on our radar? Can we work on it? How can we help as a commission? We've got a special session of the legislature called. Do we feel that this is one of the issues that should be taken up in special session, whatever those policy changes are that we needed to provide that discretion? So thanks, Amin, for.
Thank you, Efrain. Judge Wing Gutierrez, go ahead.
Yeah, just I'm applauding the efforts of AB 63. If we can give maximum flexibility to the grantees to be able to pivot their boots on the ground, they're going to see what their communities need. And then I think for us as commissioners is just we're going to be evaluating the grant applications, and so it's up to the service providers what they see and how they're going to prioritize their needs. So to the extent, I guess my question is, to what extent can the commission allow discretion? And I know IOLTA funds are really dictated in terms of what the statute requires, but so to the extent that we have that, the Justice Gap Fund to be able to allow some discretionary funding, that would be great. I mean, I think that's the question is, we need to be able to allow our grant recipients to pivot. So to what extent do we have, or can we give them that flexibility?
Thank you. Well, let's go ahead, Catherine. You got your hand up. Catherine, you're muted.
If one looks to the past to predict the future, the proposed cuts were wide and deep: elimination of Medicaid services to all kinds of people, elimination of all kinds of social services. So I think within the IOLTA grants, people have the flexibility to pivot. And I think some of the questions in the special session is, how do we elevate the discussion about the need for legal services of all kinds, additional immigration services, other services, through equal access or special programs, to grant programs that the bar could administer. And I think some of us are thinking about how to do that already. So I think we have to sort of take the current circumstances and figure out the opportunities to protect legal aid at a point in which federal funding for legal aid is probably highly at risk, to my thinking.
And then I'll just add also, like, aside from our grant funding, I think the commission and the staff can do a lot to support the programs, whether that be through a convening or brainstorming or focus groups. Like, there are kind of other mechanisms that we can do, like, pretty quickly mobilize. And I think that will go towards when we have our in-person meeting in February. But in advance of that, we can also work with some commissioners, and I'm getting ahead of myself, but there is a proposal later on that talks about the new infrastructure of the committee. So those committees can get going and get up and running. Then we don't, some of that work can be done before we meet as a whole in February. So we can move quickly, Efrain.
That's good. Thanks, Juan. And that, I was going to mention something along those lines as well. I think there's a lot we can do to facilitate, communication, ideas, sharing of ideas, efficiencies within the use of funding, and kind of working together, having organizations come together. And I think we've started doing a lot of that, and that's sort of built into some of the things that we've talked about in terms of the mission of the commission and how we want to achieve our goals and the goals of the community. And I think this is now going to be put to the test, and give us an opportunity to sort of rise to that goal. So thank you guys for your comments. I guess, did you have more on 6033?
Not on 6033, which one quick update before I turn it over to Crystal is Elizabeth and Selena worked also on some legislation to increase our summer fellowships. So there was a $5 opt-out in the attorney licensing bill that now is increased to $10. And so we are able to double that program, and it's a wonderful program. And Elizabeth actually has a presentation later on about the Justice Gap Study, and like there was a recommendation that came out of the 2019 Justice Gap Study that the State Bar produced that said, and I'm paraphrasing now, that to increase kind of the pipeline for legal aid attorneys, you should fund summer fellowship. So we took that recommendation from the Justice Gap Study, and we did advocacy, and we were able to have this money go towards there. So $5. It was funding about 70 summer fellows, but now that's doubled. We'll be able to double that amount. So it's a wonderful program. I mean, that's a high volume amount of summer fellows across the state being funded at levels that are higher than they were previously. So we really, really do think that this is going to increase the pipeline. And the staff is like tracking the demographics. And this is one of those projects that we were working with our sister organization, CalHFA, when Judge Rossi was the chair over there. So it's a great program, and we're very, very happy that now it's $10. So more to come on that.
Crystal? Sure. Thanks, Juan. Just a quick administrative update for the commission. So Rule 2201 of the State Bar Rules of Procedures requires that the Chief Trial Counsel recuse the Office of Chief Trial Counsel when an inquiry or complaint is received by OCTC about an employee, member of the Board of Trustees, or an attorney who within the past year had a relationship to the Chief Trial Counsel, or where the circumstances of the complaint render it unlikely that the attorney will receive fair treatment or the public will not be protected. Why does this relate to the commission? To accurately assess the need for our Office of Chief Trial Counsel recusals, the State Bar maintains a Rule 2201 conflict of interest database to document individual level data. So all sub-entities, including the Legal Services Trust Fund Commission, members are required to complete the 2201 limited questionnaire. I want to just make an announcement during this meeting. It'll be linked after the meeting in a follow-up email. It's a very brief 2-question questionnaire that we kindly ask that you complete by the end of the month, just so we're ahead of the December deadline. I believe all the new members have submitted it, so this is sort of an announcement for all the current members. Thank you.
Great, thank you, Crystal. All right, let's move into the staff report. We've got an update on the California Interagency Convening Legal Aid from Chris McConkie.
Hello, everyone. Hello, new commissioners. I'm really excited to work with you. My name is Chris McConkie. I'm a program manager in the Office of Access and Inclusion, and I'm reporting back about a very exciting event that happened in mid-September that State Bar staff sort of previewed at the commission's meeting in August. And we wanted to report back on just kind of like how very exciting and successful we think it was. So the meeting is called the California State Interagency Convening on Legal Aid, kind of a long name, but the idea was the State Bar of California, the California Access to Justice Commission, and the Legal Aid Association of California. So all three of them like kind of shared leadership in nearly all respects to sort of bring together several state agencies in California to discuss how government in California can partner or collaborate with legal aid to enhance government's delivery of services for indigent Californians. So it's sort of like, how can legal aid help government maximize its the effectiveness, the efficiency, and equity of governmental services on behalf of indigent Californians? We had a tremendous turnout as far as number of agencies and number of people in the room. So we were expecting kind of like 30 to 40-ish representatives. I think we got up to about 50. We were kind of hoping for 12 to 15 state agencies that would have the strongest nexus to performing a government function, delivering services to, or perhaps performing some kind of a regulatory role that directly impacts indigent Californians. And I think we got up to 17 agencies, including, just to name a few of them, the Governor's Office, the Office of the Attorney General, the California Health and Human Services Agency, the Department of Healthcare Services, and many others. It was a very exciting event. It was 4 hours. It was on September 12th. The 3 co-conveners welcomed everyone. We had a keynote speech by State Supreme Court Justice Kelly Evans. We had the U.S. Department of Justice join remotely. This was an in-person event, but the U.S. Department of Justice, their representatives were mostly on the East Coast, joined remotely to give a really inspiring talk about how the federal government has been partnering with legal aid for the last 10 years to enhance federal services for Americans. They sent someone to attend in person. We had 2 panels, like kind of like working lunch. It was a really kind of energizing and inspiring event. We're very lucky that we had Catherine there from both the commission, both commissions, the Legal Services Trust Fund Commission and the Access Commission. We had Amin and Erica Connolly there from the Legal Services Trust Fund Commission. And we had Judge Rossi, who also served in the role as co-MC. And Judge Rossi was making the change from COAF to the Legal Services Trust Fund Commission. So it was just it was really well attended. I think it all came together. We just wanted to report that back. So we do want to keep the momentum going. So we're continuing to work closely with the Access Commission and LAC to keep these agencies, and hopefully over time add more state agencies, to really seriously consider partnering more than they might already be doing with legal aid to enhance government services in California. And some ideas we have that we're still exploring with the Access Commission and LAC would include a directory for that would be kind of a closed directory for those government officials that want to network with one another to pursue that concept further. Maybe working groups to explore particular topics like DEI or aging public policy. And then a series of sort of like written briefs as appropriate that might follow particular meetings. So just to kind of keep the conversation going and just further develop this model. Elizabeth, Catherine, Amin, Judge Rossi, Erica, Dwan, did I leave anything out in the way? Bridget was there. I see Bridget. Hi, Bridget. Our special counsel, Bridget there, RED, Leah Wilson was there too. Did I leave anything out that would be helpful to share?
I think that's great. There is going to be a report that's going to come. We couldn't get it prepared in time for this meeting, but if it comes out before, we'll share it with the commission, of course.
Right, thank you, Amin.
That is so phenomenal, Christopher and everybody involved. I just love it. It's just exactly in line with our strategic planning discussions. I mean, that's tremendous. Has this ever been done before this way?
This was. Sorry, go ahead, Dwan.
I was going to say, not in California, a meeting. There was some legislation that LAC tried to propose a few years ago to start a formal kind of layer agency in California that, because of budget funding, didn't get passed, but we haven't had an organized kind of meeting like this. And, you know, I was on another panel at the ABA to present on this model with the layer folks at the White House. And there are other states that are doing this. Arizona has a similar model that we modeled off of what they're, but it is a, you know, it was quite an undertaking to do it. So we wanted to pilot as a kind of a 1 day, half day convening to see, but because there was so much excitement, and I think there's just a lot of opportunity there for us to work with agencies to work with each other. And again, going back to Efrain's comment, like this also could be a good opportunity for us once we get our bearings and figure out what the commission wants to do or where we want to lead into to again reconvene these agencies and talk more.
Well, thank you. Great job. To everyone that were able to attend that. And it's just beautiful work. Thank you.
And so that was on the planning team. I'll say it was a really lovely opportunity for the State Bar to collaborate with the Legal Aid Association of California and the Access to Justice Commission on something that just felt like very fun and energizing and creative and like actually had an impact. It was kind of like more of those opportunities, I think, and I'm like inspired by that we got to do that.
I'll just add quickly, just to echo what you've all been saying, but they're really what you can tell there just was a real desire for this from everybody, especially at the state level. They were really excited about this. They were sharing. Judge Rosie, I heard you and somebody else talking about from a different division. Oh, you do that? Oh, we should do that. So it was just really great to see. And I know the governor's office too, that helps, to support it, was very happy with the turnout, and everyone was looking forward to more convenings like this. So I just really hats off to all the staff and to LAC for helping coordinate it.
Absolutely. I'll just add, I thought, having been there, sort of sitting with folks, there was a strong interest. There was a lot of collaboration happening in the moment, like throughout the day, in a way that was, didn't feel like it was just kind of like chit chat, that sort of thing. It was like really kind of sharing ideas, sharing concerns that people had about how things were operating, issues that they may have had. So I have a feeling that there's already ongoing sort of ripple effects happening from that convening in terms of like direct interactions that may be happening between folks who make connections there. And I think there's a lot more that we can do to build on that foundation for sure. So thank you to staff for doing it. I thought it was really well done. I think you guys did a fantastic job, and thanks for the coordination that involved, and for the work that was done with our liaisons as well. It was fantastic. Okay, Chris, you've got the next agenda item as well, I think, which is an update on care funds administration.
I do, and for this one, I have just a few slides, so I'm going to share my screen. Okay, you should be able to see the slides in a moment. Okay, so later on in the agenda, there's going to be a proposal for sort of like how the commission approaches its committee work this year. But this was a particular topic for which the commission has a committee that I wanted to make sure I kind of squeezed in an update at today's meeting rather than wait to see how like this afternoon's proposal turns out, because the commissions and state bars work to administer CARE Act funds it's still very new and different from the commission's work administering most other funds. And this relatively new court program had just completed its first full year for some counties, and it just felt like a very appropriate kind of report back moment. This is going to be a slightly abbreviated update because I do envision that with a potential change in sort of like committee cadence structures and charges, this will be some committees going to really dive into this soon. But I wanted to kind of do a report for the full commission. For the newest commissioners, I do have this one slide to introduce you to the Legal Services Trust Fund Commission's administration of CARE Act funds. This is my primer for you. So there is a statute called the CARE Act. It lives in the Welfare and Institutions Code. It's just a couple of years old now. And what it does is it creates a new court program. It's still new for the counties that had to launch their CARE Court program, their CARE Act programs last year. And there are many counties, most counties that haven't even launched yet, but will be launching by the end of this calendar year. So it's still very new. And in this new program, adults with statutorily qualifying severe mental health issues, that's the phrasing from the statute itself, can access behavioral health care, medication, housing, and other community services and supports. This is a civil process. Although, as you're about to hear in a moment, public defender offices will be providing the civil representation in most counties. So this new program launched October 1, 2023 in 7 counties. The statute refers to them as Cohort 1, and December 1, 2023 in Los Angeles County. So in 2023, 8 counties launched their CARE Act programs. This commission and the State Bar administered their funding and reporting pursuant to the Budget Act of 2023. The CARE Act requires all remaining counties in California to launch their CARE Court programs by December 1 of this year. So by the end of this year, it will have launched statewide. The courts must appoint qualified legal services projects, so right, those nonprofits that this commission already funds, to represent those who are the subject of a CARE Act petition. The law calls them respondents, so CARE Act respondents. Where QLSPs are unavailable to represent Californians in CARE Court, the court will appoint a public defender office. That was true for most counties last year, and it's going to be true for most counties this year, that the public defender office for that county is the one that will be representing respondents. Because QLSPs decided for most counties to not apply to perform that role. So the last thing I have in the way of background is the commission funds QLSPs and public defender offices to provide this representation. It also funds qualified support centers and can fund other entities with the requisite expertise and experience to provide training and technical assistance to implement the CARE Act. So as I said, the commission and State Bar has now administered funding and reporting for a full year's worth of CARE Act program activities. The cohort 1 plus Los Angeles counties had the following 2023-2024 funding recipients. The data I'm about to present to you very briefly on the next couple of slides reflects this cohort. That was their funding added up to $21.42 million for a year's worth of work. They actually have 18 months to spend that down, but it was kind of reflecting one budget act year, one state fiscal year. You can see the 7 counties were Glenn, Orange, Riverside, San Diego, San Francisco, Stanislaus, and Tuolumne. LA also launched last year. San Francisco had 3 providers, 2 QLSPs, Justice and Diversity Center and Legal Assistance to the Elderly, and their public defender office. And then we had 1 entity that was providing training and technical assistance. That was the Office of the State Public Defender. Okay. And this is a quick update. I just have a couple slides on this. So in the first year, so this program ran for the 7 cohort 1 counties from October 1, 2023 to September 30th, 2024. And then for Los Angeles, it was 10 months, December 1 through September 30th. So it's 12 months of data for 7 counties and 10 months for LA. Those counties opened 722 cases. They closed 257 cases. A CARE Act case can take a year or more to close. So a lot of those cases, understandably, were still open. If they opened a case last spring, it's likely going to, it might stay open through next spring. They reported spending over 34,600 hours, 2,000 of which were in court to represent respondents. They provided CARE Act advocacy in over 1,400 hearings or appearances, and we have guidelines for them as to what a hearing or appearance for the CARE Act constitutes. And 1,100 negotiations. The Office of the State Public Defender held 11 live trainings, 5 on-demand trainings, organized 2 convenings. I believe both were in person and relatively highly attended, and provided 32 instances of technical assistance. We're filing an annual report with the Judicial Council that we're still going through and making sure that we redact any categories for which we have too few data, where it might risk someone's privacy to report it. So we're kind of doing that due diligence. So I just kind of wanted to report some really high level figures here. Many of the respondents for CARE Act in the first year were male, at least 62%. And I just say at least because I'm excluding the ones that where the office reported unknown. They let the respondent identify their gender identity. So 62% at minimum male, were mostly racially diverse, at least 62%. Identified as a race or ethnicity other than white, or identified as multiracial, and unhoused at the start of representation. Many of them were unhoused, at least 34%. Petitioner types. So the CARE Act specifies who can file CARE Act petitions for someone to go through this civil process. Most of those statutory categories are listed here. I kind of rolled up a couple into the last row. But you can see that overwhelmingly in the first year of the program, it was family members of petitioners. I'm sorry, it was the respondents' family members that filed the petition for them to go through this process to receive community services and supports, followed by behavioral health agencies, and then fewer than 10% of the petitions were from the remaining categories. And I understand I only have like a few minutes on this one, so this might be my second to last slide. But about 35% of the cases have already closed, most before they got to what the CARE Act calls graduation, as the term it uses, from the ultimate result of a CARE Act case that makes it all the way through the process is called a care plan or agreement. And that's where the respondent and their representative, the QLSP or the public defender office, comes to either a voluntary agreement with a county behavioral health agency, which kind of sits on the other side of the aisle, so to speak, or the court just enforces what's called a care plan for the respondent to get community services and supports. And then once that plan is completed, the CARE Act says the respondent has graduated. So most in the first year of the cases stopped before graduation. Almost all of them that have closed before graduation. The following 4 reasons were the top reasons why it ended early. The client either didn't have, it was determined late, probably relatively soon after the petition was filed, but after the public defender office was appointed, that the client didn't actually have a statutorily qualifying severe mental health issue. The client became enrolled or was likely to enroll in behavioral health treatment. That's actually an off-ramp for CARE Act cases. The client was unlikely to benefit from a care plan agreement. If the court thinks that it's unlikely to be sufficiently beneficial to the respondent, the case terminates, or other reasons. And the big one here was trouble finding and engaging clients, because as I mentioned earlier, they're often unhoused at the start of the case, so they can be hard to find and it's a voluntary process to get them to voluntarily engage. So my last slide. So the Commission and State Bar are administering now state fiscal year 24-25 funds. I was reporting on 23-24 funds to provide services for all 58 counties, because all of the counties are going to have to launch by December 1st. So for this fiscal year's funds, we have one support center. It's the Disability Rights Education Defense Fund that will be providing some training and technical assistance for QLSPs representing respondents, 57 county public defender offices, or if the county contracts for that function, it might be like the private law office equivalent for that county. San Francisco is the only county where it's just the QLSPs representing respondents with 24-25 funds. And the State Bar is in the process, nearly done, signing funding agreements with all these providers for all of these counties so that they'll be ready to go on December 1st. We're having a panel for the new and incoming Respondents Council on November 21st that will feature representatives from the public defender offices of Riverside, Orange, and San Diego counties so they can share their advice and experience with the new and incoming Respondents Council. We're holding drop-in hours at least twice this month where these counties can just join me in a Zoom room and ask their questions about funding, reporting, and their office's role. We'll be doing a reporting webinar in December to walk them through the report forms. And we've been, for the last several months, doing a lot of one-to-one technical assistance calls with each county that asks for it. And for some counties, multiple calls, just to make sure they understand their role with this relatively new program. Okay. I was told to keep my update to 5 to 10 minutes. So that's my CARE Act administration update. Was there any questions?
Aaron, go ahead.
Yeah, thank you. And thanks, Chris, for that update. As a new commission member kind of getting up to speed, I'm curious to know, is this the first time the commission has distributed funding to public defenders' offices? That's, outside the model that I'm used to.
Yes, it is. Yes. To my knowledge, it is the first time.
I mean, I can't imagine how much work, to, build these relationships and reporting structures with 58 county public defenders' offices that have a very different business model than civil legal aid. I mean, how is that going in terms of straining the resources of the, the State Bar staff and the public defenders' offices staff?
I'll start and I'll let Chris jump in, but I'll start in terms of when we negotiated this grant, We were in conversations with the legislature because we were a little bit nervous. We hadn't obviously infrastructure for our 100 grantees, but we didn't feel like we were in a position to monitor other state agencies.
Yeah.
And so we did negotiate that we would collect the reporting requirements. However, we weren't going to monitor in terms of compliance. So that took off kind of a heavy load. But with that said, it was still a lift, and I'll let Chris speak to the kind of building
For
out
the
infrastructure for that.
Yeah, for the public defender offices, and I think for the grantees, for our like 2 grantees last year, I think the monitoring compliance looks similar to what the commission would normally exercise in the way of monitoring and oversight. But yeah, for the governmental public defender offices, it's just the reporting. For the counties that have governmental public defender offices, it's actually been a dream. It's been so easy. They understand their role under the CARE Act already. They were waiting for the state bar to reach out to them and explain the reporting requirements and sign a funding agreement. What we learned, it's been wonderful working with every county, but what we learned is that actually a lot of counties in California, I can't remember the exact number, but it's somewhere between like a dozen and 2 dozen, are small enough that they actually contract out this function, public defender services, to a private law office, as opposed to having a governmental public defender office. And for those counties, in some cases, the private law office with which they already contract was happy to also take the CARE Act cases that might come to that county. But in some counties, that office wasn't interested in amending their contract to do that work. So the county administrative office or the county counsel's office has had to find someone else to do it. Or, so there's been a slowdown for some counties as they figure out who will be providing this representation. Sometimes the private law offices needed a little bit more information as to what this work is going to look like for them. Yeah, so for the counties that have governmental public defenders, it's been like these very smooth sailing. It's been a pleasure to work with every county, but the degree of hand-holding has been different depending on sort of how big they are and whether or not they outsource, they contract for this work with a private entity.
And going forward, I know, December 1st is the rollout statewide of all this, and it looks like the funding's already been allocated by the legislature for 24-25. Do we know yet? I mean, we had a massive budget deficit this year. Do we have any idea, is funding for this going to continue going forward?
It's a really great.
Any tea leaves?
It's a great question. Yeah, and as several commissioners knows, Commissioner Blakemore knows, and Judge Klein knows, and everyone who sits on the CARE Court Grants Committee knows that the funding projection actually changed pretty dramatically last spring. It went way down from where it started, like in early 2024. The projection for state fiscal 24-20 year, the current state fiscal year's funding dropped, I think, like 60% by the time the budget bill had passed. So it's hard to project. At this point in time for next state fiscal year, which will begin next June 30th, the 25-26 state fiscal year, I think it's prudent to wait until the governor releases a budget proposal in January, just because it changed so much last spring. I wouldn't take for granted that it wouldn't change again.
But with that said, this is one grant where we do have a lot of contact with the Department of Finance, and we've been told this is a governor's priority, and we've been kind of pushing for them to do multi-year grants, which they seem to be receptive to that fact, so that there's more stability. They did say that with the first year or two, they wanted to keep it as 1-year grant so that they can evaluate, but they were very, very open to at some point being a multi-year grant.
Thank you.
Something else that the Department of Finance and the governor's office was really receptive to, which was really wonderful, was for a lot of agencies administering the CARE Act, other agencies than the Legal Services Trust Fund Commission, State Bar, and Respondents Council, my understanding is actually have to give back any funds that remain at the end of the state fiscal year, and then the next budget act will appropriate the new fiscal year's funds, but they kind of send back whatever they had left over. For this role that the Legal Services Trust Fund Commission is funding, representation of respondents, they're actually, even though they get every budget act gives them a new amount for that year, the budget acts have also been giving Respondents Council, these public defender offices and QSPs, an extra 6 months to keep spending their previous fiscal year's funds. So to help avoid cash flow issues if there's a delay in the arrival of the next state fiscal year's funding, or if they had funding left over and they needed it to continue to provide uninterrupted representation, they could continue to do that for an additional 6 months. That hasn't been true to my knowledge for other agencies' funding under the CARE Act. So that's also been really great. And the spirit of that, my understanding is the governor's office really wants to protect the relationship between the respondent and their attorney and not do anything funding wise to try and risk that or any kind of delay in the representation.
Perfect. Thank you, Chris, and thank you for that, Aaron, as well. Okay, any other comments on this item? I think let's move to the next agenda item, which is our minutes from the last meeting, the August 9th, 2024 open session minutes. Did anybody have any comments, any proposed changes to those minutes to share? Okay, do I have a motion to pass those minutes?
I will motion.
Okay, thank you, Jacqueline.
I'll second.
Yes.
This is Tammy.
Tammy, okay, great. Thanks, Tammy. All right, let's do a roll call vote.
Thank you. Allocation,
Yes.
Babcock, Blakemore,
Yes.
Campbell, Galkin, Gonzalez, Fong.
Get my yes.
Yes, okay, thank you.
There it is.
King,
King here. Yes.
Klein,
Yes.
Mahoney,
Yes.
Morales,
Yes.
Pryor,
Yes.
Rosie,
Yes.
Sandville,
Yes.
Smith.
Abstain since I was not present.
Oh, I should have said, for our new commissioners, even if you weren't present, you can vote in confidence of your colleagues if you so choose to a yes, or you can abstain. Your call.
Thank you for clarifying that. I'll just abstain for now. Thanks for clarifying.
Stalker,
Yes.
Vargas,
Yes.
Escobedo,
Yes.
Melrod,
Yes.
Elseraff,
Yes.
Connolly. All right, that's 15 yeses, 1 abstention, motion carries.
Perfect, thank you. Okay, so the next thing is that we've got a consent calendar. We've got on the agenda, there are 9 items. We're going to pull one to have a discussion about. So 6.1 through 6.8 remain on the consent calendar. And I'm going to open it up to if anybody has a motion on those matters. Those are matters that are, the materials were in the agenda and available for folks to look at. And unless there's any questions or any concerns about those, I'll open it up to any motion.
I move approving the consent calendar, but I abstain from 6.1 and 6.4.
Okay.
I'll second.
And Efrain seconds.
Wonderful.
Okay.
All right, I'll do the roll call vote. Allocation,
Yes.
thank you. Babcock, Blakemore,
Yes.
Campbell, Galkin, Gonzalez, Fong.
Yes.
King,
Yes.
Klein,
Yes.
Mahoney,
Yes.
Morales,
Yes.
Pryor,
Yes.
Rosie,
Yes.
Sandville,
Yes.
Smith,
Yes.
Stalker,
Yes.
Vargas,
Yes.
Escobedo,
Yes.
Melrod,
Yes.
and then I have your abstentions captured, patients. Elseraff,
Yes, and I'm saying to the extent that any of them relates to the Legal Aid Foundation of Los Angeles.
all right, Connolly. All right, so that is 16 yeses, motion passes.
Okay, thank you, all, and let's get into the meat of our, well, more of it. I think we've had some really great discussions so far, and I appreciate the discussion. And just one point of procedure, Dwan and Crystal, I think in terms of 6.9, is that, can we move that into at the end of the business section, or do you guys want to do that at the
It's up to you,
upfront?
but Erica is on deck, Erica Carroll in our office, so if we could do it now, I think that would be probably better for her schedule.
Yeah, let's go ahead and do that then. We'll move to 6.9, approve the 2025 IOLTA and EAF budget submissions, and I'm going to turn it over to Erica Carroll.
Oh, there she is.
Sorry about that. Just
There we
had
go.
to rejoin. I'll share my screen. Okay, good afternoon, everybody. For those I haven't met, I'm Erica Carroll. I'm a lead program analyst with the Office of Access and Inclusion. Here to give you an update on the 2025 IOLTA and EAF budget submissions, which were discussed last week with the Eligibility and Budget Review Committee. Catherine Blakemore is the chair of that committee. I'm sorry to pull this item from the consent agenda. I just have two very brief updates, and happy to answer any questions after that. The first is that the list that appeared in your meeting materials for the grantees that are recommended for approval for their budgets, unfortunately, due to a formatting or clerical error, some of the names are not actually completely visible in that attachment. And so we just wanted to offer some clarity that about the 115 grantees that are intended to be on that list. And so what we've done, and I don't have to go through every single one of these, is but we have incorporated all of the 115 grantees into the PowerPoint, because that'll be posted as our meeting materials for reference later. So apologies for anybody who reviewed the materials and perhaps saw any missing names, but we do have all of our grantees listed here today. And then the other reason that we asked to pull this is because the resolution that was originally proposed in the materials that you reviewed included a contingency for Asian Pacific Islander legal outreach. At the meeting last week, the organization had included some capital additions in its budget that the committee was not recommending for approval, and staff was not recommending for approval due to a lack of documentation for them. And so the grantee was given some more time to make the necessary revisions to present essentially an approvable budget. And they did so, and staff has spoken and met with them this week and reviewed everything that was resubmitted and satisfied that the organization made the appropriate changes. And so we wanted to remove that part of the resolution, as there is no need to include a contingency at this point. And so our recommendation and the committee's recommendation would just be to approve the 115 grantees for 2025 IOLTA and EAF budgets that were submitted and included in the PowerPoint that I just sort of ran through. So happy to answer any questions.
Catherine, I'll make a motion to approve that recommend resolution.
I'll second that.
Okay, thank you, Catherine. Thank you, Angie. Dwan, did you have a comment also
I was
before?
just say, is the updated what you just shared, Erica, is that slide in, like, if the commissioners wanted to pull it right now, like I see Aaron's pulling it up, does that match? Like the PowerPoint
This
is
will be
on
posted
there?
after the meeting,
After the meeting,
but
okay.
part of the meeting materials
Okay.
before today. Yep.
Okay, so we've got a motion and a second. I think we can move into roll call vote.
Great. Alakani,
Yes.
Babcock, Blakemore,
Yes.
Campbell, Falcon, Gonzalez, Huang,
Yes.
King,
Yes.
Klein,
Yes.
Mahoney,
Yes.
Morales,
Yes.
Pryor,
Yes, I abstain as to Ventura County Legal Aid.
Rosie,
Yes.
Sandville,
Yes.
Smith,
Abstain as to Family Violence Appellate Project, and otherwise, yes.
thank you. Stalker,
Abstain as to Legal Services of Northern California and Capital Pro Bono, and yes, otherwise.
thank you. Vargas,
Yes.
Escobedo,
Yes.
Milrod,
Yes, abstaining as to Central California Legal Services and otherwise approval.
yeah, Elstra,
Yes, with the same abstention for LAFLA.
okay, Glenn Connolly. Great, that is 16 yeses, 0 no's, motion carries.
Right, thank you. Okay, well, let's move into 7.1, which is to approve recommendations to restructure the organization and responsibilities of the committees under the Legal Services Trust Fund Commission. I'm going to turn it over to Mara and Erica.
Thank you. And actually, it's going to be myself and Jonathan presenting today.
Okay,
So
terrific.
share my screen. So this agenda item is with respect to a resolution from a working group to approve recommendations to restructure the organization and responsibilities of the committees under the commission. The Legal Services Trust Fund Commission has a strategic plan, their 2024-2028 strategic plan, which includes 5 goals as part of that strategic plan, all meant to increase access to legal aid. So to advance the Commission's mission, increase efficiencies and effectiveness, increase accountability, transparency, and visibility, increase collaboration and coordination with a diverse range of voices, and to find new opportunities to enhance the Commission's impact. So with this strategic plan in mind, an infrastructure working group was formed to reassess the distribution of grant program responsibilities and restructure the organization of the committees with the goal of optimizing operations and enhancing the Commission's ability to efficiently and effectively increase access to legal aid services. We held a working group meeting on October 4th and received memo feedback. The working group members were Erica Connolly, Justice Rodriguez, Jason Gulkin, and Jonathan Sandville. And at this time, I'd really like to extend my gratitude to them for their time and support for this work. It was very, very helpful to receive their insights and guidance as we looked at the current structure of the Commission's committees and think about ways that we could reorganize the work that needs to be done so that the Commission can perform that work and increase access to legal aid while, really pursuing the goals laid out in the strategic plan. So the current structure of the Commission's committees include an executive committee and then 7 specialized committees. And this is just a very brief overview. I'm sure you are all familiar with at least some individual committees. Some of you may have served on many of these committees. But the specialized committees really focus on varying aspects of grant oversight work and on each separate grant program. The idea of the infrastructure working group was really to look at the responsibilities and the work products and processes of each one of these committees, to identify common threads, to look at the strategic plan, and to create a more streamlined approach that would reduce administrative redundancies and again, make the Commission more efficient and allow us to funnel or continue to funnel as many resources, monetary and otherwise, towards the goals of the Commission and towards legal aid services. So at this time, I'm going to hand it over to Jonathan Sandville to present the options and recommendations that the working group has developed, and then to present the resolution after we've had some discussions of these 3 options. Jonathan?
Yes. So there are three options that was recommended based upon the conversations with the working group. And again, this is done for a number of reasons, one of which is to make sure that we're focusing on governance issues and really not getting into the weeds of the work that needs to be done. And it's also to maximize efficiency, if you will, to streamline the work that's being done and to address challenges related to communications and the complexity and the overburdened responsibilities of staff that's working on it. So there's three options. The first option is option A, which shifts from the 8 committees mentioned to 4. And next slide, please. And then there's option B, which also shifts from 8 committees to 4, but it gives the option to, I'm looking through my notes. It gives the option to, Mark, can you enlarge the screen, please? To focus on scoring as well.
In option A.
I'm sorry?
Sorry, go ahead.
Okay, yeah. So as mentioned, there are 3 options. Options A, B, and C. The first option, option A, shifts from 4 committees to 8 committees to 4 committees. And option B also shifts from the 8 committees to 4 committees, but offers the option to I'm sorry, I don't have my glasses on, so I can't see the screen. Can you mention the difference, Mara, in option B?
Oh, sorry about that. So in option A, is that better for you, Jonathan?
Yes, there we go.
Truncated, but yeah, that's.
Okay. So in option A, the infrastructure working group includes scoring applications as a part of the program development and impact committee's responsibilities, versus option B, where the same 4 committees would be formed. That would be the executive committee, rules committee, compliance committee, and the program development committee. But option B would remove scoring as a responsibility of the program development and impact committee.
Mara, can I have a suggestion? Maybe if you go back to option A and just, I know it was in the memo, but could you talk about each of the committee to give the commissioners kind of time for it to soak in a little bit, the committee responsibilities?
Absolutely. So the executive committee would continue to exist with slightly different oversight. It would still manage government issues, commission compliance. It would look at audit reports. It would have a hand in communication strategy, IOLTA distributions. It would still be a part of commissioner appointments and onboarding of new commissioners, but it, in addition, would also look at future trainings and educational responsibilities for commissioners. The Rules Committee would be a committee that focuses on codification and rulemaking. And while it seems like this committee has a shorter list, for any of you that have been involved in this work, this would still be a very heavy committee. All of the committees would be meeting 4 to 6 times annually and have 6 to 8 commissioners, with the exception of the executive committee, which would be chaired by the commissioner chair and then the chair of each subcommittee. So that would be 4 commissioners total. The compliance committee then would be looking at overseeing grant compliance of all grants and recommended corrective actions as necessary. The idea being that if there are corrective actions or grant compliance issues that might be affecting the same program but across different grants, that conversation could happen once with a program rather than happening across 3 different committees for each different grant program. This committee would also look at reviewing and approving late or incomplete budget submissions, budget modifications, and all carryovers greater than 25%. It would also be responsible for determining IOLTA and EAF eligibility and reviewing ILAW reports. The Program Development and Impact Committee is sort of the forward-looking and engagement committee as we see it, and would be looking at innovations at collaboration, stakeholder engagement. Significant changes of current funding programs would be run through this committee, evaluation of current funding programs, and then within option A, scoring applications during the first year of all funding programs. So this would also include the approval of a rubric, which for those of you that have been a part of application scoring, the rubric is the guiding light and principles that we implement when scoring applications for discretionary fundings. The strategic plan goals that align with each one of these commissions are at the bottom. So as you can see, each committee, new committee, proposed committee, is aligned with achieving certain strategic goals as laid out within the strategic plan. So that's option A. Option B then is different in that it removes the scoring responsibility for the Program Development and Impact Committee. So in this scenario, that committee would still be looking at major changes to funding programs. They would still be taking part in approving the rubric, but in terms of scoring the actual applications within the first year, that would be something that staff would do and then report the funding recommendations as they do now. Jonathan, do you want to cover option C?
Yeah, the last thing I'll say about option B also is that one of the main differences is it allows us to focus on governance. So rather than there's some commissioners who are very much interested in being in the weeds of the programmatic issues, but then there are others that might not be. So option B differs in that, so that that work is done by the staff and the commissioners can focus on governance. And for option C, the difference in that is a fifth committee is added to, which is the application scoring committee. So that committee would be added, and you don't have those in options A and B. So reviewing and scoring of the applications of IOLTA and EAF grant programs.
Yeah, so option C is a little less streamlined. It brings us to 5 committees. And yeah, then you'd have one committee where committee members would be scoring each of the funding programs. That would be their sole responsibility.
Okay, thank you, Mara and Jonathan. Selena?
I was going to offer technical assistance to anyone whose eyes are as old as mine. If you're viewing this on your own computer and your Zoom is updated, at the top you'll see 2 tabs similar to website tabs. One says webinar, and that's how you see people's faces, and the other says Mara's screen. And if you click on the 3 dots, you can zoom in and move things around just so that you're more able to see the detail on slides if they aren't part of the packet. I use this all the time, so I just wanted to share that, because if you're not on Zoom a lot, you may not realize that there's an ability to zoom in on other people's presentations.
Thank you, Selena.
Thank you very much. And unfortunately, once you share your screen, you can't see much of anything else. So I appreciate the assist.
I use this daily, so happy to share the hack.
Thank you, Selena. Catherine?
Thanks for all the work and thinking about this. I actually just I'm trying to kind of meld what I think happens now with what happens later and make sure I understand that. So sometimes there are policy questions that relate to how grants are administered and how the scoring ends up being done. And I'm not sure I understand which committee would be responsible for that function, or if no committee is responsible for that function any longer. That's my first question.
So I'm going to go back a couple.
Yeah, great.
And I'll go back to option A. So under the proposal, option A, the Program Development and Impact Committee would still be looking at significant changes of current funding programs. And this would also include like a brand new funding program. So the establishment of a rubric, or if there is a substantial policy change, substantial change in funding that makes us rethink the way we need to administer a funding program, that would all come through the Program Development and Impact Committee, which would then also report ultimately up to the commission.
So this sounds like, I guess that sounds to me like changes that are happening external because someone raised them as opposed to the commission raising them. So like, maybe I'll be more concrete. There was agreement that the way in which care court funding was distributed would be re-looked at starting this fall, which is now almost gone. And so I'm trying to understand, by way of example, is that something that the Program Development and Impact Committee would then take on?
As a significant change to a current funding program, yes, that would be something that they would be taking on.
So is what I described a significant change? That this came from the Care Court Committee the last 2 years and has kind of get pushed off because of, it's a new program, etc. So I'm just trying to make sure like that topic at least has a home. So it fits within that is what I'm hearing.
Yeah, I think if it's going to significantly change the way the program is administered, that's definitely something that would be discussed within that committee.
Okay, great.
Yes.
Okay, and then the second is around the scoring of the application. So not really speaking to who should do it, but ultimately the commission is responsible for approving the funding, right? And so I see 2 places where either I think one committee does the EAF funding, I think IOLTA EAF funding, and it looks like potentially nobody does funding of the other smaller grants, which are actually fewer now. But how does that then get presented to the commission so that people understand in maybe a more robust way what was happening with those than appearing on a consent calendar by way of example? Because I think we have a responsibility for understanding what we're funding in some detail, and it's been fine when it goes through a committee because then there's commissioners looking at it. But if it's a staff only process, what kind of information do you expect the commission members to be getting so they're making informed decisions when they're approving that?
Mara, I can help with that. And I invite the other working group members too, because I was part of the working group as well. So the idea was to streamline it, was the working group wanted to advance option A. And really this is to streamline it since they felt like the staff had the expertise to score. However, there within A for scoring, that's for the first year to kind of, so that we're all on the same page with the scoring rubric.
Yeah.
Within option A, it's a new grant, then the commissioners on that committee would help score. But if it's a routine grant, then it would be staff led, and then it would go to the commission to approve once it's.
Yeah. So I understand all of that, Dawn. I'm trying to understand when it goes to the commission, what kinds of information. So this is to me a somewhat significant change, and I'm actually not opposed to it. I think commission members need to have information. If you're approving like $252 million that's being distributed, it's helpful to know not just a listing like we've been getting now, because other people looked at it and asked questions about it. So I'm just trying to understand what that looks like in terms of commission approval.
It would be, what we had envisioned would be an agenda item at a commission meeting like this, and there would be a presentation.
I'm sorry, there's a lot of background noise, like echoing on your end.
Yeah, sorry, outside there's a emergency siren.
Oh, sorry, okay.
So we would present it like we did with the previous agenda items today. It would be a presentation from the staff in terms of how many organizations applied, what the scoring rubric was, and then we'd have the attachment of all the. So I imagine for, I don't know, like a new grant, if you wanted to see how in-depth would be, I would imagine, I don't know, maybe a 15-20 minute presentation on average at a commission meeting. That's 4 hours.
So is that maybe something to be sorted out then, depending on the model that's approved? Is that maybe fair? Like, what does that look like so people feel informed about what they're voting on?
We can include it, we can discuss it. I think that was one of the, we felt like might be a point of discussion. And that's why you'll see in several options that it turns on around the scoring, because we thought that that's the piece that might solicit a lot of discussion. And so I think the working group is open, but I really would invite the other working group members to chime in, because we did have a really robust conversation over several kind of working group meetings on the scoring.
There are a couple folks with hands raised. Let's go to Tony.
Thank you. So first off, I want to say thank you for the committee for, taking your time, putting a lot of thought into this process. I really appreciate it. I'd like to first say that I love just like any opportunity to further streamline our processes and further identify and be more specific on roles and responsibilities. So I really appreciate this effort. The one question I have, and maybe it'll help a lot of the members here better understand, is that like how will our roles shift from our current committees into these newly established committees? I don't have any. I just feel like there's like bits and pieces of roles and responsibilities moving around. So it'd be nice to better understand where that is. Really, to Catherine's point also, is to make sure that we don't miss kind of our existing roles and responsibilities, right? And then if there is a change in our role and responsibility, I think we should further understand what that change is and what that is going to look like moving forward. I'm not opposed to like I feel like option B allows us to really be more in the governance structure where what we're meant to do versus the daily application scoring. I participated in that, and I feel like staff is very well trained, and they can do that very, very well. And I had to really come up to speed on that. But I think as we work through and new committee members come in, there may cause some inconsistencies in the scoring, whereas with staff members, they're well trained, they do it, and they can, I think, look at the scoring more across the board because they have the experiences and the background for all of the individual entities that are providing applications for that. But I'd like to just hear more about like how our existing structure is going to kind of fit into these various, and the roles and responsibilities are going to fit into these various new committees.
I can answer that, Tony. So the proposal, if it wasn't obvious, was we would do away with the other structure. So Tony, I think you're on the Summer Fellowships Committee, so that committee would go away. And what the working group was going to propose after we decided on a new structure is that if anybody has interest in a particular committee, if a new committee, assuming that something passes today, then they would email me and Crystal, and the assignments usually for committees are done with the chairs, and then Erica and Amin would take that into considerations when they figure out who to place on which committee. So there would no longer, say if one of these options passed, Tony, there would no longer be a Summer Fellowships Committee, just as there would no longer be a Partnership Grants Committee. And so the commissioners would then fit into kind of the new committees.
Okay, so all of our current functions now go, like, if I'm in a committee that no longer exists, then I basically get a new job.
Yes.
Okay.
And they don't all change, like the rules committee, if it wasn't obvious too, that committee will largely change. I think the membership though might move around a little bit because of the needs of the other committees, but that's one committee that will stay largely the same. The radical change in this are the two new committees, right? The compliance committee will now absorb the compliance across all of our grants, and then the program development committee is the committee that's looking towards like trends and the policy work, I would say, for lack of a better committee. So those are two different committees. And I can't remember the other committee that you might be on, Tony, but I know that you're on the summer fellowship one, so that would go away.
Okay, Efrain?
Thanks, Amin. Again, like my other fellow commissioners, applaud the work of the Infrastructure Committee. So I wanted to just offer up a couple of observations. I really don't have any questions I need to get answered, and they're more in the spirit of, with all things systems change, just, iteration and refinement. That's really the spirit of these. So one is in observation on option A, program development and impact committee would seem like a really heavy lift. So just doing a second pass there and saying, okay, is everything here? The thing that stood out for me on that one is, the differentiation between the compliance committee's role and then also putting evaluation in the program committee. And so wondering where are there dependencies there in those two, so that, given some of the public comment today, we don't have, great imagination on the evaluation side and what that should look like. And then compliance committee being just as creative and imaginative on what things we want back from grantees, and we're rolling out all kinds of things on them in there. So just offering that up. And then the other, just two more quick thoughts. One is on the program side with regard to this conversation about the scoring during the first year. I just wonder, because we want to be streamlined, are we agile enough to take things like that and say, is that better served through ad hocs that could come in, be formed and disbanded as soon as that exercise is done, versus some loaded thing and weighing down the committee, when these are things that may be few far between or maybe very specific and laser focused. So just wondering, that might help us lighten up the load on that committee. And then the final to the points that were raised, Catherine's point is, it did raise a question for me. Well, is that something that like rules committee could deal with? I've experienced in our practice, like usually before an RFP goes out for one of these programs, along with the rubric, it usually ends up coming to the commission, and the commission can look and adopt those, is my recollection. I might be off, but that seems like an important rule. I wonder is that something that the rules committee would make sure to set in place, and saying, we're not going to launch or use rubrics that didn't come for the commission's approval first, regardless of the committee's valiant efforts and great informed work. So thanks. I'll go on mute.
Thank you, Efrain. Those are great comments. Mara, did you want to address any of those?
Yeah, I think those are helpful points, and I do acknowledge that, as with any new structure, there will be some adjustments within the first couple of years, and I know we acknowledge this within the memo as well. I agree that having the commission's input and approval and understanding of the rubrics and what is being funded is critical. And so I think whichever option we adopt, we can definitely continue the conversation around making sure that that information is provided to the commission, so they're receiving all the information that they need in order to make informed decisions.
Judge Rosie.
Thanks. I just wanted to make, I'm new, but I want to make a sort of a quick plug for option A, and still having the commission involved in the application scoring. And I say that in part because the partnership between COAF and the Trust Fund Commission on the summer fellowships is actually how I became so acquainted with the Trust Fund Commission, and it really is a valuable partnership between two state bar entities. And I was lucky enough to be involved with the application scoring for the fellowship for the last 2 years. You know, to Tony's point, and Afreen, we did it together as well, and Vanetta was involved. You know, it's not a light lift. It is a pretty significant lift, but it's also, I think, a really valuable way, especially if you're a new commissioner and someone like me who comes from a administrative law and a judicial background and not necessarily a legal aid background, to really get a flavor of who our grantees are. And while there is no question that state bar staff could do this, and state bar staff are brilliant and provide valuable insight, I think there is something that the commissioners add to the process, especially when we're each bringing our own scores together and we're going over them together and we're talking about what each of us saw, and what those of us saw were missing. So I think it would be a shame if we didn't have that as part of the commission's work still. And again, I know it's a heavy lift, and I know there's lots of other things involved, but I just wanted to throw that in.
And I apologize, I can't see anybody raising their hand, so I don't know if I'm cutting in line, but I do want to say that we totally agree with you, Judge Russ, and that's why I think the option A still provides an opportunity for commissioner scoring on that first year, so that we have that engagement, and again, to calibrate, to make sure that, you know, we're scoring it the way that you all envisioned the scoring rubric to be developed.
Yeah, and I'll just add one more thing, and I know we've got a couple more folks with hands up, but just to say, you know, you're 100% right in terms of getting to know programs. There's a lot of materials, a lot of ways to do that. One thing that I want to make sure to plug and encourage folks to do is to also be involved in the monitoring visits that happen on a regular basis. And it's a really good way to actually meet the folks and kind of sit down and kind of entrench yourself with a particular organization and learn a lot about what they do and how our money and the money that we're administering impacts what they do. But Justice Rodriguez, go ahead.
Yeah, I was glad to participate in kind of this process, and I think it was very intentional. I think one of the things was that this was guided by our most recent in-person meeting of trying to leverage all of the experience of our members and really being able to think about kind of policy and direction. Partly because I think our current organization has grown through a process of accretion with new legislative proposals and other policies. And so trying to look at kind of analogous entities and trying to figure out kind of the most streamlined approach to really leverage that work. And so even in these committees, I think really trying to be very thoughtful about how to balance the work so that, as it is currently the case, where the Rules Committee and Executive Committee is doing so much of the heavy lifting of one sort, whereas all of the kind of screening and scoring is a lot of heavy lifting, lots of meetings of another sort, really trying to balance that out. I think option A was intended to kind of be a good transition because it really kept members, particularly for first year funding programs, connected. And then by being connected and giving that scoring to help inform staff's work in later years and trying to do that scoring. So really trying to leverage both staff work in later years, but to have members really connected. So a lot of, I think the feedback that I'm hearing from members is super helpful, and in many ways echoes a lot of the conversations that we were having as we were sorting through these various options and why ultimately option A is the option that we were recommending. Thanks so much.
Thank you for that. Jacqueline.
Yes. So a lot of great points being shared. I appreciate those as to help me understand. So I have a question about where it says on option A, application scoring during the first year. So that's on the performance of the grantee during the first year, right?
No, that's when we're selecting the grant recipients. Like if we get a new source of funding, that's deciding who gets the funding at
Oh, okay. So that's about
But
who
evaluation
gets the
does go through that committee too, because I think there was a comment earlier about we don't want to lose the evaluation. The evaluation does go through program development and the impact committee. So that wasn't obvious before.
Okay, so that's part of the scoring for the actual grantee selection.
So there's that piece, the application scoring is the selection of the grantees, but under the program development and impact committee, if you go back to the slide that has more information on option A, there is evaluations in that too, evaluation of the grant program itself. Right there, above the highlighted evaluation of current grant. And I think that's what you're asking, but that does go through that committee.
Okay, so, and every year, are the is a grantee performance scored every year?
It depends on the grant, but I'll give it, I guess, the example today that we had a public comments on an agenda item that's going to come later about changing reporting requirements. That would go through this committee to kind of vet new reporting changes and evaluations.
Okay, because, you know, I agree with, I think it's really important to consider, you know, the point that Catherine was making that the scoring it's very important for commissioners to understand comprehensively overall this issue. And for me personally, it really, you know, will help me to have a good overview of all of the programs we're funding and what kind of coverage we're providing through our communities. So, you know, I'm particularly interested in that. I think it's very important. So, for instance, if, you know, if that option doesn't pass, that includes the scoring, then how do we address the scoring? How will that be handled? Will that be through ad hoc committees or what?
Well, and I think we were trying to get away from the model that we're in now, because the feedback we heard that with our current structure, pretty much the one committee, one grant, that the commissioners were feeling bogged down by the day-to-day administration of the grants and the scoring. So I want to echo what Justice Rodriguez said. It was kind of a balancing act, because we understand that scoring and being in touch with the programs is really important. We're really trying to balance that with your desire that I think you've expressed through the new strategic plan to play more of a policy role, to engage in some of these discussions about trends, to do a bit more advocacy with that day-to-day administration. So we thought the good compromise was having this new program development impact committee doing, again, scoring for the first year, and then letting staff for future years continue the forum. And again, if there are like changes to what the rubric would be, it would go through the committee. But we thought that would be a good compromise to kind of manage, again, the day-to-day, because one of the things that's happened with the commission over the last several years that you've all seen is like the commission work has grown a lot because our grants have grown a lot. And so we wanted to make it tenable for commissioners to be kept engaged at the policy level and not be bogged down by so many committee meetings and so many instances of scoring. That was the desire, but
I see. Thank you for that additional explanation.
Thank you, Aaron. Go ahead.
Yeah, thank you. And this is, I think, mainly just sort of points of clarification as I'm trying to get a grasp of all the duties that have been spread across various committees to date and how this would work. I think what you were just saying, Dwan, is helpful to me. So the scoring, if I'm understanding it, is from competitive grants, right? So not IOLTA and EAF. No. So that's helpful. I mean, just one, I kind of like folks have been saying, I kind of like the idea of the commission staying in touch with that and just ensuring sort of getting off on the right track. I mean, another thing that was occurring to me is if that committee or I guess it would be that committee, would have the ability to sort of take test samples, like maybe we'd like to review 10% of what how the staff has done the scoring, and just take a look at it to make sure that the way you all are doing your work is in line with what the commission is expecting to see, and putting out the rubric. So I guess that's just a little suggestion. And then the evaluation, that was a question I had coming into this, and what you were saying, I think clarified it for me. I mean, we have the compliance committee reviewing reports, but then the other committee doing evaluation. And I guess it would be helpful to understand the difference between that. I mean, when you're reviewing a report, presumably you're not just reading it to read words, you're reading it for a purpose, to evaluate it in some way and have that inform the commission's work. So I'm wondering how those 2 points in particular work together, and if it makes sense to combine them maybe under one or the other. And then I guess my last point, just the word, I think an earlier person made a much more articulate comment, which I think kind of gets to the root of what was troubling me about the word compliance, but it doesn't seem to encompass everything that we're talking about here. It sounds a little punitive, like we're trying to catch you being out of compliance with something, and we're going to be in the weeds of all your reports, and but that's not what is here. Here we have eligibility and like helping programs work through their budgeting and making sure it's in line with how the commission intends the funds to be spent, and then reviewing reports. I mean, those impact litigation and advocacy reports are very substantive about like a lot of the big ticket impact work that the community is doing. So that's not a compliance, really. It's more than that. So I think there's like, to me, a mismatch in that word, and also just like how this committee is being envisioned, I guess. So it's kind of a hodgepodge of thoughts.
I guess I'll share also that there's one option that's not presented on A, B, and C, is that as the staff is doing scoring for each of these grants, we can still have commissioner involvement if that's what you all choose, the direction you want to do, but not through a committee. We did think about maybe an option is to have like a list of commissioners that would like to score, and then once there's a scoring opportunity that happens, then that cycle, then you can volunteer, but we would keep it to less than 2, so as to not trigger a committee. And then there would be, say, 2 commissioners and 2 or 3 staff. And so the scoring team would be comprised of 4 or 5, like it usually is, but done outside of a committee. But then you would still follow this kind of option A, first year to go through for, and then for future years. So we could do some hybrid of that. This is just a starting point. We would like, though, I'm speaking on behalf of that working group, though, today to be able to pass a structure, so that beginning of the year we could slide into our new structure rather than to delay it one more time. But I think the working group is open if you all want to make modifications. But that was something I wanted to share that could be done pretty easily.
Angie, go ahead.
Thank you. I know I'm missing something. I'm on the Eligibility and Review Committee, and we do the EAF and the IOLTA, which means now under the new either A, B, or C, the Compliance Committee becomes the Eligibility and Review Committee, but for all the grants.
So I think this is a good, if I can step in and clarify a bit. So this new structure would be in place of the 8 committees we currently have. So the current committee assignments would go away. And what we would request once we've adopted a particular new structure is that you email Dwan by the end of day on Wednesday, next Wednesday.
That's not my question. My question is the work of the Compliance Committee would be all the grants, but it would be the same work that is currently now just IOLTA and EAF for what that committee does, but that new Compliance Committee would do the IOLTA and EAF plus all the other discretionary grants.
Okay, Angela, let me help with this. It's really a reimagining of the eligibility budget, this compliant, and we actually talked about this at length at the working group. It's not taking 8 committees and shrinking it into one. It's taking aspects of that because it's a reimagining of the staff role and the commission role. So for IOLTA and EF as an example, you all would still vet IOLTA and EF eligibility issues, but we would save like really the significant issues, right? If there are new grantees that are applying as they are this year and the last couple of years, you would feel those, you look at them a little bit more carefully, but we wouldn't do as extensive a reporting on, like, I would guess, the non-significant compliance issues. So it's not taking 8 of those EBR committee meetings and then putting them into the 4 or 5 compliance committees plus all the other. It's still going to be a heavy lift of a committee, and this is where we probably will need to recalibrate after the first year to see how it goes. But it's not taking like 30 committees and putting them into 30 meetings and putting them into 5 meetings, if that helps. But it would absorb some of the work of the EBR committee.
So what of the work that the eligibility review committee does now, what of that goes away under the new structure, I assume, to the program development committee?
So there's like and I'll let if Erica's here, she can speak to it, but if she's not, then I'll do my best. You have a couple meetings, say, on the ILAW report that will be shrunken down. And if for this, and this is why we use the word compliance, so this doesn't feel comfortable, we can change it. That piece of the ILAW piece is really about if there are activities within the ILAW report that don't kind of comply with our governing authorities, this is where it would be. And there aren't actually with ILAW that many substantive issues anymore. We've gotten to a point where there's a lot of agreement between the commission and the staff, so there aren't actually a lot of issues that get risen by ILAW. If it's ILAW, but in terms of impact, this is where it's a little bit confusing. It would go to the program development and impact committee, and that's why we use the term compliance intentionally. And I know that term is triggering, so I think we're open to, but it is compliance in terms of rules and authorities.
Okay.
And that's why it's determining IOLTA and EF. So we're making sure that they are meeting those statutory requirements in order to be eligible for IOLTA and EF. But it would be the difficult compliance issues, right? And I think you probably could think about our last couple meetings, some of the programs that we have talked about heavily. Those would be kind of the compliance issues that would go to the compliance committee.
Okay.
So we've got a couple more hands raised. I also want to get to any public comment. Looks like we got one former commissioner who's got a public comment as well. So I'm gonna see if we can get through a few more of the comments that I've got of the commissioners, starting with Catherine.
I was just going to say, I didn't say before, but I actually think a strength of the proposal is this expansion of the executive committee. And that'll help ensure better integration across the committees. So we've sort of focused on, I think, a lot of the details about what do each of the other committees do, but I just really wanted to call that out and commend the work that was done to rethink that in a way that I think makes that committee more robust. And to Aaron's point, I would love if we could find a name for a committee that was something other than compliance. So whatever that, I don't know that I have a great suggestion, but even something about, eligibility and monitoring sounds friendlier than compliance, I think. I don't really know what the right words are, but I find it hard to believe members are going to be intrigued by being on something whose function looks like your job is to, just take care of the problem. So I understand that's an important function, and I think it nicely belongs within that, but maybe there's a different way to name that and group that. So
thank you, Catherine. And that idea actually came from you. We integrated for having each of the chairs on the subcommittees. And the other thing I'll point out about the executive committee, if you haven't already seen, that they're suggesting to create an emeritus an advisory panel of former commissioners to kind of come up with kind of our policy work. And this is also another juncture where if you all wanted more commissioner or former commissioner scoring, that could be an avenue too, where we have like a pool of former commissioners that might be interested in evaluations or scoring, that they're kind of on deck to help the staff and the commission.
Great. Yeah, Chris, go ahead.
I was just going to say in kind of my 4 years in this office, I've observed that each grant has the partnership grants, each of the homelessness prevention grants, care grants, they've all kind of developed in super thoughtful ways, but to a point where they all look very different. And there's like a lot of inconsistencies that are not inherently problematic, but it would probably be much more efficient and predictable to consolidate things in this sort of way, where if like all new grants just came to the program and development and impact committee, or in major changes, like that committee could ensure that there's thoughtful consistency across grants and things like evaluation or where they deviate from one another, that there's like a reason for that. I really love that about this proposal. I wanted to, and I would fully defer to Tamara and Dwan 100% about this, but I wanted to just say in response to something Catherine had raised earlier, which is if the commissioner's role happens to change vis-a-vis like scoring applications, how will the information flow from staff to the commissioners change to like a comment to like make it so that the commissioners are still getting the information they need to make informed decisions? I think that was like a really great question. And I defer to Mara and Dwan if that's already baked in here, but I think that if for like the program and development and impact committee, that's something like that committee could explore right away. Is like what is our role now, and like what information do we need to be able to just make when we vote, like we know what we're voting on. Like does the memo need to read differently? Do we need different attachments? Do we need different kind of communication with state bar staff? So I thought that was a really good point that would be something we would explore. And then I also loved Ephraim's point that with any really big change like this, you might need to refine and iterate. And I'm wondering if there's a way to sort of, adopt a structure today as outlined in the working group's proposal and leave a little bit of room for each committee to figure out its processes and information flow and meeting cadence and structure to optimize and refine. And like what I would call like the implementation here, like that sort of flexibility can be part of it.
Yeah, and I think once a new structure is formed, it will be a part of the growth and development of each committee to create a way to communicate with the commission as a whole, their new area of expertise in a way that is comprehensive. And it is going to look different, but it's going to look a lot less specialized than the committees we have now. And to Chris's point, it is going to look a lot more consistent across the program. So yes, I think this will be an ongoing process.
Yeah, Ephraim.
Yeah, thanks. I just wanted to say that I shared my feedback, but in supportive of entertaining and moving the structure, and would just kind of in line with Chris, a little bit mind melding with Chris today on if we could say let's adopt and then ask whether the committee or members of the committee, like I think it'd be good to adopt some formal charters for this so that we could review them periodically and change them. And not have to digest this on the big picture. I know this is moving to a restructure. So if we said yes, restructure, then maybe our next step could be, come back and iteratively bring back and say, here's the new charter for the executive committee. We've worked out the details. Let's make sure we're all aligned and adopt it together as a commission, assuming we all agree. But I'm supportive of adopting the structure. And so I'm just thinking ahead of my request would be, could we actually get specifics and get some real charters back and make sure we all agree and charter each commission? And then that way we could review it periodically.
That's a great idea. Judge Juan Gutierrez.
Okay, so I'm making a couple of assumptions, and the first is that the grant applications are not public documents. And if that's the case, then I'm not sure that an emeritus commissioner who doesn't have an official status on the commission can review the grant applications. That's one point.
They are public documents, Judge.
They are public documents?
Well, if someone does a CPR request, we turn it over. They are in that sense. I guess they're not public in that
They're
we're
also
not
posted as part of meeting
Yeah,
materials.
they're very public.
I was going to say, I think we also, at least historically, set up commissioners with access to the application platform. so that they can log in if they want and actually just like look at the application as submitted. I'm unsure, maybe we stopped doing that last year or something, but I think that was something that we used to do.
Okay, good.
Yeah.
You clarified that for me. So they're public documents. That's not a problem. So I take back my comment about the emeritus commissioners. So then the next question really harkens back to the very first point, I think, Catherine, that you raised, which is sort of it hints on the concept of what is the duty of us as commissioners. I'm only an advisory member, but you know, we're managing a huge fund. And so there is some level of obligation where we can't just delegate to staff to do everything. We have, in other words, my bottom line point is, it seems to me that it behooves us to have at least one or two commissioners. And I'm not sure what that threshold number is that invokes whatever rules, but at least one or two commissioners that participate in the evaluation of the actual grant applications rather than relying on summaries and recommendations from staff. And that is not to you know, say that staff is not capable. I think it recognizes two things. One is that the commissioners all sound very much desiring to be involved and to know our programs that are seeking funds and the types of services they're delivering. And then secondarily, that sort of we have a role and an obligation and a duty to roll our sleeves up and get our hands a bit dirty. Those are my comments.
Can I ask, is it more palatable, say with option A, to take out the scoring and remove scoring from that fourth committee, and then just say for every scoring cycle, we will solicit 2 commissioners to be part of the scoring team? Is that something that is would be more supported?
So it's Catherine, I think that's more supported. And I actually, like, I appreciate the desire to, and I think it's actually necessary to think about the structure today so we can move forward. And I think maybe the answer to some of this is the idea of developing these charters underneath that would clarify the responsibilities, and potentially with a compliance committee, which had, you know, there's, I think, a name challenge with that. So we could address some of that. And so I think that's where this application review could also be done. I don't particularly like the idea of removing it entirely from what we're approving. So it's sort of more like, if I were making a motion, I would say approve option A with the addition of an expectation that at the first meeting of each of the committees that they would develop a charter that would further clarify their role, which could include, you know, could include the review of applications in some way, and that then the commission would approve the charters at the meeting whenever we're meeting next.
Yeah, that's a great idea.
After I think the first of the year meeting or something, it could be like a good discussion to have even in person potentially. So I guess that's how I can see this, where we can make forward progress, but leave open some of these details that so many people have raised as really good questions that I think would benefit from a subsequent commission discussion. And so it, you know, but it allows us at the same time to have this new structure and move towards appointing subcommittee chairs and all of those things. So that's my suggestion for a recommendation, but I don't want to make I don't want to make a motion to approve that if there's lots of more discussion to happen so that everybody's voice can be heard.
So we've got a couple more folks. I want to get to the public comment. And then Jacqueline, after that. Jim Meeker's got his hand up in the attendee pool. Can we elevate him?
Yeah, well, I appreciate a chance to comment. I realize that I'm a dinosaur has-been ex-commissioner, and my observations may not be that pertinent today. For me, the good news, having been involved with this scoring rubric from the beginning in the early days, it's nice to see that it appears that the staff has become very comfortable with it. And it's not surprising to see that commissioners who are not used to this idea of actually scoring grant proposals are still a little bit uncomfortable with it. I think it's important, though, that they do be involved with it for several reasons. One is it helps them understand how the staff go about grading these different proposals. It also I think the commissioners need to be involved because they may want to change over time how much you weight various parts of the rubric as things change and the environment change. And I think it's important that the compliance element of the grant be involved. The same people involved with the scoring is also involved with the compliance. And I just speak from experience with the homelessness prevention grant. I mean, if I had a grant, when I was chair of that committee, if I had a grantee that was scored very high on the rubric because they had an innovative outreach program to the rural areas, which was part of the scoring rubric, and all of a sudden under compliance, they want to change the amount of resources that they want to go for rural access and change it into, say, like educational programs, I would feel very different about that compliance as opposed to a program who did not originally have a rural component, so it wasn't part of their scoring rubric final score, but to decide to change and put some more resources into that. To me, those are completely different things. And if you're having compliance people judge that proposal that weren't involved with the original scoring rubric, I think you lose some information there. So anyways, and finally, having the commissioners involved with the actual scoring, I think is important because they learn, but it's also important, I think, for the staff so that the programs out there know that their final score was not just a function of staff, but was also a function of the commissioners. And thanks for the opportunity to be heard.
Thank you, Jim. It's great to hear from you. Let's go to Jacqueline.
During the discussion, it was mentioned that an option of having a couple of commissioners involved with scoring. I think we should keep that number flexible so that if there are more than 2 commissioners who want to be involved, that can happen.
My only response to that is because the 2 number is, so then we don't unintentionally form a committee. It might trigger a quorum because then we're going to be going back essentially to our old structure of having a committee per grant. So that's why there's a number 2.
But Juan, you mean that just for clarity of process, you mean 2 per grant, not 2 for everything?
No, 2 per grant. So it could be different commissioners.
So,
I would suggest different commissioners.
Right. So there would be opportunities across the grants similar to there are now for people to be involved. I just think I think there was a misunderstanding.
Oh yeah, sorry. Not just 2 commissioners that would do all the you wouldn't be able to do it. There's like 10 discretionary grants. It would be 2 per grant. And what I would suggest is if we're going to move in that direction, not just like 4 or 6 commissioners, but we have like a really robust pool. And this is why I say like this is where we might want to think about like emeritus commissioners. We want to widen that for a diversity of kind of thoughts and backgrounds and so forth.
And well, that really helps. Thank you, because I was thinking altogether 2 commissioners.
Oh, 2, yeah.
Oh, my goodness. So 2 per grant.
2 per grant. 2 per.
What is the typical grant range that we usually have? How many grants approximately on average?
Chris, you know off the top of your head how many grants? I want to say it's like
guesstimate
10, but two are by formula or IOLTA and EF, so it's about 7 or 8 discretionary grants per year. Okay. And then they really range though in work. Like our partnership grants are about 40 applications. A lot of them are recurring applicants, so it looks very different than say like a new grant that's starting up. Like homelessness prevention or 70. We had 70 something grant applications, so the intensity is different and the cycle is different too. So if we go in that direction, what we can do is like share when the grant period is, because that might fit better. Say if you have more availability in spring, you might want to volunteer for partnership, and you have less, so that they're all kind of different cycles and they demand different kind of time.
So overall, for all of the grants, there's an opportunity for at least 2 commissioners to be part of the scoring.
There could be, yes. So that's the direction you want.
Okay, got it.
We're very open to that.
So I think that's Juan's modification of, which is helpful because I think there's been a lot of comments about that. of the options that are before us, that I think she's suggesting that it be pulled out of the Program Development and Impact Committee, and that there be an understanding, though someplace represented on the chart, that there would be opportunities for 2 commission members to participate in the scoring of all grants, which would, so that's how that's being proposed. And is there a reason, I guess when I was thinking about this, is there a reason we can't call the compliance committee like the grants administration committee or something that?
Yeah, I think Eric, you had another suggestion.
I was thinking something along those lines, like maybe grantee eligibility and review, or grant eligibility and support.
Yeah, I think any of those are fine. So like maybe we just have a placeholder that talks about it being a grantee committee or grantee eligibility and whatever else you said. I think that's fine.
An iteration of that, of grantee eligibility and support.
Grantee eligibility. I'm sorry, I can't.
Sorry, grantee eligibility is support, a version of that. I don't know, maybe we'll have to think about it, see if we can come up with a better version of that, but grantee eligibility and support.
I just think for purposes of a motion, it would be nice to have a different placeholder because we've had a lot of comments about that. So grantee eligibility and support committee, and then it can be further worked out. Does that work for you, Juan?
We could also have the committees finalize their names as part of their chart.
That is great.
Yeah, that's great.
So I'm going to make a motion to approve option A, but remove the highlighted green, to instead say that there will be grantees, that there will be opportunities for commission members to score all grantees up to 2 members, and that in addition, that each committee will develop a charter in specifying what work it will be doing that will be reported back at our in-person meeting. And as part of that charter, I confirm its name to reflect the responsibilities that it has.
Mara, do you want to pull up can you make that change on the motion?
I'll need to change the slide, so bear with me.
And then while Mara is doing that, I think Mara mentioned this at the front end, but for these new committees, if there is a particular committee that you want to join, can you please email me and Crystal by next Wednesday? And if there's a particular committee you would like to chair, Erica and Amin are asking for a very short statement of interest, 1 paragraph, 2 paragraphs, really not more than a page, of like your background and why you think your skill set would be good for that chairing that particular committee, by next Wednesday as well. And we're going to try to move really quickly and do the assignments just so you all can get on your calendar what committees you're on. We're hoping everybody will get their assignments by Thanksgiving.
So you said assignments plural? Are we,
Oh, I think we were thinking 1. It works out with the 3 committees.
Yeah, that's what I thought. Your committee assignment singular is what I understood this to move towards. I just wanted to be clear.
One per commissioner, unless you would like to serve on 2, then let us know and we'll see if we can make that happen. I don't think anybody would want to do all 3. They're very heavy committees, each one of them.
And I do think it's sort of baked in the idea that this is going to be something that we'll evaluate as time goes on to make sure that this is working.
Yeah.
It's something that we've done a pretty good job of, I think, in connection with a lot of the work that we're doing through the rules committee and through this whole process of kind of reimagining what our work is. And I really do want to add a statement of gratitude and appreciation for all the work that the working group did and coming up with this, because there are a lot of different issues to be aware of and to be thinking about. Consistency, something that has come up a lot, is something that I think a lot of us have been thinking about for a long time, is how do we maintain a level of consistency across grants, across years, when we have a rotating group of people on a commission. And I think that's one of the strengths and benefits of having a lot of that, on the ground scoring being done by staff who are there day in and day out and see a broader picture. I mean, when I joined, I was on, a particular grant committee. I didn't have visibility into what was going on in other grant committees and other eligibility, so I do think that having this sort of elevated approach where you're not jumping right into just scoring grants, but we're able to sort of have the commissioners be more involved in big picture things and then getting involved in the grant scoring, I think is going to be really helpful to, especially to sort of onboarding new commissioners. Jacqueline?
I just wanted to know, can I see that chart with the 4 options again? That page?
Sorry, I'm in the middle of editing the resolution.
Oh, you're editing.
Very sorry. I'll share my screen in just a
Okay,
moment.
no problem. Thanks.
We appreciate you doing that, not while we're all watching you.
Oh, it's
Sorry,
very.
it's hard to do it on the spot. So
It is hard.
Yeah. And just in terms of process, I know we've been going for a while. I think once we get through, let's get this vote in and then we'll do a short break.
And can you remind us what we're doing after we come back?
Sure, we've got a few more agenda items. We're going to have Erica, Carol, and Catherine will be presenting on the request for reconsideration of the 2025 IOLTA and EAF funding denials. And then we're going to approve updates to the 2025 grantee reporting requirements. And we'll get an overview from Elizabeth and Erica Carroll on the 2024 Justice Gap Study and the delegation of authority to support the final recommendations for that to our co-chairs. And then we'll review the administrative calendar, and then we'll get a couple of liaison reports from the Judicial Council and LAC, and we'll be done. I'm optimistic that we'll be done in advance of our 4 o'clock timeframe, but we shall see. So thank you, Mara. I'm going to turn it back to you.
Everything, but I also know Jacqueline had asked to see another slide. Do you want me to go back to which slide was it you wanted to see?
I think it's just the
slide that
A.
presented all the options. Just a quick reminder of what that looks like. I just want to see. Okay.
So I think, Jacqueline, where we've moved is that option A, which talked about a particular committee having scoring during its first year, that we've sort of moved away from that, as I best understand it, so that instead that ongoing, there would be the opportunity for 2 commissioners to participate in the scoring of all of the grants. And so that's the difference that we've seen, in part being, in part given what you and others said about the importance of commission member involvement in that process. So that's kind of the tweak to that's then reflected in the work that Mara did. Sorry.
Yes.
I don't think I've even met you, so my apologies for not knowing how to pronounce your name.
It's fine. So this would be the wording of the new resolution. Resolve that the Legal Services Trust Fund Commission approves the reorganization and restructured responsibilities of the committees operating under its purview, as described herein as option A, with scoring applications during the first year of all new funding programs removed, an expectation that the opportunity for application scoring of each funding program be provided for 2 commissioners annually, and with the expectation that each new committee develop a charter and finalize its name at its first meeting, to be reviewed and approved by the commission at its February meeting.
I would only make one suggestion, is maybe take out annually, just in anticipation if we get a grant opportunity that might require like twice a year or some other frequency.
Yep. There we go.
Okay, I guess, do we have a motion to begin with?
So I will move the resolution as it's presented.
I'll second.
Okay. Jonathan seconds. Thank you. Okay, let's have a roll call vote.
Elakani,
Yes.
Babcock, Blakemore,
Yes.
Campbell,
Yes.
Falcon, Gonzalez, Huang,
Yes.
King,
Yes.
Klein,
Yes.
Mahoney,
Yes.
Morales,
Yes.
Pryor,
Yes.
Rosie,
Yes.
Sandville,
Yes.
Smith,
Yes.
Stalker,
Yes.
Vargas,
Yes.
Escobedo,
Yes.
Milrod,
Yes.
Elsarov,
Yes.
Connolly. Right, that's 17 yeses, 0 nos, motion carries.
Okay, thank you, everyone. Let's take a 5-minute break.
Can I just thank Mara for that agenda item? She's worked several months on it, and I just, on a practical level, that shrinks 50 commission meetings per year, notice meetings down to 20. So again, that will really, really help so that we all can focus on, again, the policy and the governance work.
Congrats and thank you.
Phenomenal.
Everyone's input, it's very much appreciated.
Thank you, Mara. Okay, everyone. See you in a few minutes. Books are filtering back in. Let's give everybody another minute to rejoin.
Once I think we see more faces on the screen, I can take roll call again, just to confirm that we have quorum before we move on to our next business item.
That'd be great. That's a great idea, Kristen. Great. Do you want to go ahead and do that? Let's do that now.
Sure, I'll take roll call of our voting members just to confirm quorum.
Great.
Connolly, Elsarov,
Here.
Escobedo. Back.
I think Efrain's not back yet.
Okay, I'll go down the list and see if we, Milrod,
Here.
Allocation,
Here.
Babcock, Blakemore,
Here.
Campbell,
Here.
Galkin, Gonzalez, Huang, King,
Here.
Klein,
Here.
Mahoney,
Here.
Morales,
Here.
Pryor. Showed here, okay. I'll skip for now. Rosie,
Here.
Sandville,
Here.
Smith, here, Stalker,
Here.
Vargas,
Here.
Okay, so we have 15 members who, with the roll call, we have quorum, so we can continue on if you'd like to meet with their business items.
Yeah, in the interest of time, let's go ahead and get started. Our next agenda item is Erica Carroll and Catherine Blakemore on the request for reconsideration for the 2025 IOLTA EAF funding denials. So I'll turn it over to Erica.
Thank you, Amin. So another item from the Eligibility and Budget Review Committee, the request for reconsideration of 2025 IOLTA EAF funding denials. For the benefit of those who were maybe not on the commission or at the last meeting in August, as part of the application review process, the commission makes determinations about whether organizations are eligible for funding in the coming year. And this year for 2025 funding, 3 organizations were found ineligible. 2 of them have submitted requests for reconsideration. And so I just want to take a moment to go over the governing authorities that apply and then talk a little bit about the requests that we received. So The two organizations that were found ineligible were for incomplete applications. Specifically, they had failed to submit an audit or a reviewed financial statement by the deadline. So typically, the deadline is May 1st of every year. Staff can provide an extension through the application deadline as deemed appropriate. And then past the IOLTA EIF application deadline, that extension could only be granted by the commission. And so in our schedule of charges and deadlines, when the commission is considering an extension, there is a limit to that where it says under no circumstances shall such extension be granted beyond the date when grant allocations are determined. And so the commission met on August 9th, made eligibility determinations, including the denial for these two organizations. And then staff started working on the funding formula and ran that formula on August 14th. So that was the date on which allocations were determined, and then released the following week so organizations could start their budget proposals. At the time the organizations were denied, shortly thereafter, staff sent out a letter on behalf of the commission indicating the denial and the ability for organizations to request reconsideration. So under Rule 3.691B, organizations have 30 days from the time that they're given notice to submit their request. And so we had United Core Alliance and then Yuba Sutter Legal Center for Seniors. United Core Alliance was a new applicant. It was an applicant for first-time funding. They had previously been given an extension through June 30th to submit their financial statement. Unfortunately, they weren't able to get that in on time. And after they were denied, they did submit a request for reconsideration on September 13th, which was within the 30-day window. They attached to their request a reviewed financial statement that they had gotten for their prior fiscal year. Yuba Sutter Legal Center for Seniors was an existing grantee. They similarly had failed to submit a financial statement. They were given an extension through July 15th based on their circumstances. Again, unfortunately, the organization did not meet that deadline, and they submitted their request for reconsideration on September 23rd, which was also within the 30-day window. But in their request, no financial review was attached, and the State Bar still does not have one for the organization's prior fiscal year. So in light of the schedule of charges and deadlines, and I'll just go back to that for a minute, you know, that extensions cannot be granted beyond the date grant allocations are determined, even though Rule 3.691 allows organizations to request reconsideration. Staff had discussed with the Eligibility and Budget Review Committee last week that the schedule of charges and deadlines, staff and the Office of General Counsel had interpreted this to be controlling. And so even though those organizations did submit their requests, that the commission is recommended to affirm its denial for their funding because allocations were determined before we even received a request for reconsideration. So I'm happy to answer any questions. Otherwise, the proposed resolution is on your screen.
Thank you, Erica. Aaron?
Yeah, thank you, Erica. And just a point of clarification, is it correct that the schedule of, what is it called, schedule of deadlines and charges is passed by the Board of Trustees and is in the State Bar rules? Is that?
Yes, it's contained in the State Bar rules.
There's not much we can do about what that says and the fact that it's it governs what we can do in this scenario. Is that correct?
Well, you could always, we have a rules committee that if you wanted to make changes, we can elevate it to the Board of Trustees, and all of the changes that have been elevated from the commission to the Board of Trustees to change the State Bar rule, they have approved. That's not, yeah.
This process. This particular one was created by the commission.
Yeah, that one actually was, that particular rule was rewritten by the commission a few years ago.
But we can't rewrite it like right now. So, no. Right. So it kind of governs what we do as of today. Yeah, got it. Thank you.
Okay, any other questions, comments?
I don't have another question, but maybe I'll just comment before we vote. I think, as you can maybe see, there's not much choice to approve this resolution today. But I do want to just comment as a former grantee about the difficulty of getting these audits done. And I would love it if sometime in the future the rules committee, it sounds like, can look at this and see what we can do to minimize structural barriers that we may be putting up that make things more difficult for the grantees. I think I actually came and made public comment when the commission changed the rule from, I think it used to be March 31st and changed it to May 1st because it was actually impossible for us to, we had a calendar year, fiscal year that closed on, December 31st. We didn't even close our books until February 28th because the, outside finance team that we had at the time, we couldn't close December until we closed January to prevent having to do like crossover journal entries and allocations and things like that. So we didn't even close our year until February 28th at the earliest. And then February is a short month. So of course it ends up being like the first week of March. And it was actually impossible for us to do an audit in under a month and get the board to approve it and everything. So the shift to May 1st was helpful, but I will say it was always one of the most stressful points of the year to administer as someone, just running a legal services organization to try to get that done. And I read the letters from these two organizations and really sympathized with the plight that they were in. I mean, it sounds like this is one of the scenarios where you're really at the mercy of outsiders. It's like, oh, your bookkeeper leaves and didn't take good records, and then your auditor requests whatever from some other third party, and you have absolutely no control over it. You're really at the mercy of whether your auditor can get it done in time and whether all your board members are present to sign off on April 30th so you can rush it over here on May 1st. So it's even May 1st is very difficult. And I also think that asking organizations at $600,000 a year to do full-blown audits instead of financial reviews is also, it's very difficult. It's a big chunk of their budget. So I would just advocate, I'm happy to talk with anyone, who's interested in just like further about the realities of trying to get these audits done in time to the commission. But I would love it if we could, just look at that going forward. But for today, I think it is what it is.
Thanks, Erin. Catherine, go ahead.
So I'll just make a comment as the chair of the committee that looked at it. I think people felt that it was understood the impact that it was having on organizations. And I think we tried through the granting of extensions to give people more time. So it wasn't really a May 1st problem. It was July 15th. And then I think the challenge is figuring out if you have to run the formula on August 15th, but someone hasn't provided financial statements that you can verify their extended expenditures, then what is it you should do? Because you can't hold up everybody else's grant because the program hasn't been able to get their audit done. So I think I just say it's a difficult position to be in, and of course, welcome looking at alternatives for that. But in addition, I will move the resolution.
Okay, thank you, Catherine. Do you have a second?
I'll second.
Okay, thank you, Angie. Angie seconds, and let's do a roll call vote.
Alikani,
Yes.
Babcock, Blakemore,
Yes.
Campbell,
Yes.
Pelican, Gonzalez, Huang,
Yes.
King,
Yes.
Klein,
Yes.
Mahoney,
Yes.
Morales,
Yes.
Pryor,
Yes.
Sandville,
Yes.
oh, apologies, Rosie. Judge Rosie, sorry, apologies. Judge Rosie on the call.
Looks like she may have stepped away.
Okay. Smith,
Yes.
Stalker,
Yes.
Vargas,
Yes.
Escobedo, Milrod,
Yes.
Elsarov,
Yes.
Connolly. All right, that's 15 yeses, 0 nos, motion passes.
Okay, thank you. All right, the next agenda item that we have is to approve updates to the 2025 grantee reporting requirements. We'll get a presentation from Crystal, Heidi, and Chris.
And I will share my screen.
Thanks, Chris.
Okay. And feel free to just steer me, Crystal and Heidi. I'm happy to control the slides for all of us.
Sure, thank you. All right, so for that, this is going to be item 7.3, approved recommendations regarding the reporting requirements for 2025. The memo for today, for this agenda item, sort of has a more detail. We're going to provide a high-level overview of what the proposed updates are. Broken up into 4 different parts: proposed updates to expenditure reporting, proposed updates to legal aid reporting, proposed enhanced reporting requirements for IOLTA, and then Chris will close us out with the proposed updates to support center reporting. I'll hand it off to Heidi to talk about the updates to expenditure reporting. Oh, sorry, I think there's another slide. Just to sort of with the discussion of the infrastructure, the recently approved strategic plan, we just wanted to provide a quick excerpt of strategy 3 from the strategic plan, which is to increase access to legal aid through greater accountability, transparency, and visibility. Just wanted to highlight under the 5-year plan strategies under effectiveness and accountability. We have a sort of a goal there that the commission developed, which is to improve data collection and tracking around outcomes for grantees and programs supported by the commission, including tools for grantee outcomes, evaluation, and reporting. So just tying that back and this item back to the strategic plan. All right, next slide. All right, Heidi.
All right, thanks, Crystal. I'll go ahead to the next slide. So based on our current expenditure reporting time or frequencies, there's a lot of variability between each of the grants and when they're reporting expenditures and how much insight we have into the expenditures during the life of the grant. So currently, 2024 IOLTA and EAF are now reported on different cycles. EAF is on a quarterly basis and IOLTA is on a semi-annual basis, which I will say has caused some confusion for a lot of our grantees. The bank grants they only report expenditures annually, as do the partnership grant, and then the HP2 and 4 also reported annually. HP3 reported quarterly because that was a federal requirement, as is the CalHFA grant. And then the consumer debt and the legal aid leaders report annually, although the legal aid leaders fellowship program is it's not a long window, so they just report at the end of the window. So given all of this, we've been talking about it internally, that it's when we don't have insight into what's happening in the grant spending as it goes through the grant term, we end up at the end of the grant period with a large amount of unspent funds that could have been rolled over or reallocated, excuse me. And so, for example, we just closed out HP4, and as I reported, or as is in the consent agenda, there's a lot of unspent money that's now going to be returned to the state, although we're going to try and see if we can figure something out there. But there's a lot of money left on the table, and part of that is because we didn't have insight into how the spending was going by the individual grantees. So in a way, so we can go to the next screen, Chris. Oh, I think I just said all that, so you can go to the next screen. Sorry. And so the proposal would be to move to semi-annual reporting for grants that permit carryovers. So, those grants will never be reallocated in the middle of the grant stream. We can use unspent funds in the subsequent grant period. So moving IOLTA and EAF to a semi-annual reporting as opposed to the prior quarterly. Same thing with partnership. We would have biannual semi-annual reporting there, so we can sort of see how it's going. We're not surprised at the end of the year or the grant period. And then if there's any bank grants after 2026, which we don't know, I don't think there will be, but they would be also on the semi-annual. Whereas the discretionary grants, where we do have some flexibility about reallocating them mid grants, and we don't have the ability to roll them into future grants, it would be much better for transparency and being able to predict where unspent funds might show up with the discretionary grants. So currently HP3 and CalHFA are on that model because of federal requirements. CareCourt is also on that model, but I'd like to propose that all future discretionary grants beyond 2025 have a quarterly reporting fiscal schedule. And then because the consumer debt is already, it's mid-grant and it has annual reporting in it already, we would leave that alone. And legal aid fellowships, again, because it's a short cycle, they just report at the end of the cycle. And then the bank grant as well, which is currently running from 24 to 25, that would also just stay on the annual schedule. So that's the end of my presentation. I welcome any questions if anybody wants to discuss frequency of expenditure reporting.
Thank you. And I think just for some context, that we had one resolution for all of the proposed updates. So if the commission is open, we'll just talk about the different components, figure out if you want to, if that is still tenable, or if you'd like to sort of split up the resolutions depending on sort of the feedback and discussion for the item.
And one thing I forgot to mention is we did propose, we did take this proposal to grantee feedback sessions, both the support center and the QLSP, and there was not any there was no real comments or, opposition to moving in this direction.
And can I just say, Heidi, I think the idea of potentially more frequent quarterly reporting for the discretionary grants, my sense from the feedback session was everyone understood that the point of that was to allow for reallocations during the grant period so that if a program might have funds left over and they would want another program to be able to spend those if possible, instead of everyone have to return them to, so that the Californians that were supposed to benefit from them can still benefit from them. I think my sense was the community got behind that.
All right.
Okay.
Next slide, I'll turn it back to Crystal.
Yeah.
Okay, great. Good. Next slide, Chris. So this proposed updates to legal aid reporting, this will be very quick. Just an overview, especially for some of our newer commissioners. So currently, as part of the reporting requirements, grantees submit legal aid evaluation reports on an annual basis at the end of each calendar year. Those are your case summary reports, which reports on cases closed, your main and economic benefits report, and the effect litigation and advocacy work report, the ILAW report. These legal aid reports provides data across all funding sources. That's both state bar and non-state bar funding sources. And the proposal is really administrative. It's in efforts to streamline the data collection across all of our grants. We propose 2 updates to these to 2 of the legal aid reports. Next slide. All right, so the first update for case summary report, and looking at sort of the current data that we're collecting, we notice sort of an inconsistency with the case summary report. In the EAF report, we currently collect the information about the number of people served in educational workshops and outreach events, as well as in our other grants. We currently don't have that specific data point in our case summary report. So our proposal is to add those 2 additional columns to the case summary report, just to have more visibility and more information and data, especially since grantees are reporting these outcomes across all funding sources. There was no feedback to this proposed update when we talked about that with the grantees at the grantee feedback session. Okay, next slide. Main and economic benefits report, again, just in efforts for sort of streamlining and consistency across our grantee reporting. Staff is recommending to add additional information about the economic benefit information that we are currently reporting, and grantees are reporting on those EAF annual evaluation reports as applicable to benefits that they report at the end of the year. So we would want to just sort of adopt those columns that are in red into the larger main and economic benefits report, which again, I mentioned is across all funding sources. Okay, so those are two administrative updates. The third component that I'll talk about are the proposed enhancements regarding IOLTA reporting. As a reminder, we sort of first broached this topic at a prior commission meeting. We collected grantee feedback last year, and there were a couple of proposals made ultimately back in 2024. Just based on the feedback, the commission voted not to update any of the 2024 require any specific 2024 IOLTA reporting. So we're sort of revisiting this topic with new perspectives and sort of in considering all of the different points, increase in the IOLTA distribution, for example, taking into consideration that grantees were really in favor of keeping the legal aid reports, which we had previously proposed to maybe phase out, and just trying to leverage and utilize existing data and figure out how to complement to better understand the impact of IOLTA, which I'll talk about in the following slides for our for the staff proposal. There's a lot of text here, so I tried to summarize that quickly. Okay, and just to recap feedback that was provided by the grantees on March 7, which is earlier than this last grantee feedback session in October. Again, grantees did not want to phase out the legal aid reports, so we're not proposing to phase away with them. Just because of the way that IOLTA is used, there was feedback strongly expressed that it would be difficult to quantify and track IOLTA related outcomes just because of the way that IOLTA is used in their organizations. Cases are not specifically tagged as IOLTA. Grantees use IOLTA to fill in the gaps of patchwork funding. Some use IOLTA to supplement programs and for other like reasons on how these funds are used. All right, so next slide. Okay, so the proposed approach that staff is proposing for IOLTA reporting for 2025 and beyond is one, sort of leveraging that existing legal aid report data across all of the funding sources. We have data across all of the funding sources, so one half of staff's proposal is to approximate services and outcomes that are attributable to IOLTA, sort of using that existing data that we have. And then because we know that that's not the full story and IOLTA is used in sort of a multitude of ways, we are proposing additional reporting requirements to get additional insights about how else IOLTA is used, using several points of data and that feedback from March to inform some of these recommendations.
And just let me just add there on the first point, the leveraging existing legal aid. We've consulted with our Office of Research and Accountability to see whether we could do that. So one of the things that actually a grantee suggested was, we want to keep the main legal aid reporting that's across all sources of grant funding. It's too hard to do IOLTA specific, but you all know the amount of money that each organization gets from IOLTA relative to their budget. Could you just do a pro rata and attribute that? And we weren't sure. So we reached out to our statistics and our to see whether that was a research question for them. They came back and they said, yeah, that could be a good proxy. Not exactly, but that could give us a gauge. If I'm making this up, if IOLTA is X percent, then these are the X percent outcomes. And again, it's not the whole, but it gives us at least a starting point of measurable kind of outcomes. So that would be staff, like we would do that. So that onus would not be on grantees. So I think that's one thing that would be valuable in this kind of a proposal.
Yes. And then a couple of slides I'll just maybe go over quickly, just as an example, because we have the 2023 legal aid reports. We actually did that analysis and applied it to the existing data. So using 2023 of the reports submitted by the 78 qualified legal services projects, sort of see the big picture numbers there, 73 733.4 total corporate expenditures as reported on the IOLTA EAF application, and sort of the using the same application as the sort of the source for an apples to apples. You see 39 million of the total reported IOLTA expenditures. So we're looking at the same period from the IOLTA EAF application. So a couple of points just when we did the analysis, IOLTA expenditures comprised of over 6% across all total expenditures. And then what we did is we calculated each grantee's sort of respective IOLTA percentage of like their IOLTA percentage over their total corporate expenditures, so sort of get the first half of our equation. We didn't round it because we knew that the range was really large, so we just respectively calculated it and sort of did the aggregate and summation of those numbers. Okay, next slide.